at a later date because I'm so boomer with this. It's so aggravating.
Bro, I went through this exact same thing.
I remember, and I was trolling you a little bit, and it's not funny being on the other end of it.
What's up, Rob?
You'll figure it out.
Sorry, I'm running later than normal. I just got off work and then physical. So.
You're good, buddy. You got 4 minutes.
Yeah, but I had this football coach that used to tell me, to be early is to be on time. To be on time is to be late. And to be late is to be left behind. I try to live by that motto, you know?
Honestly, I do respect that. That's one that, like, probably my biggest pet peeve in life is to be late for shit. It generates so much anxiety. So
let's be honest. If you've done enough of these panels, let's ask Gibbs. Hey, Gibbs, can you hear me? Oh, yes. You can't hear me right now.
I can hear you. I can hear you.
Okay. Who's always the last person that comes on a panel? Who's always late?
Lefties?
That's right. It's always the lefty. It's usually the lefty with the biggest channel. So, like, Destiny will be the last person there.
Oh, always. Well, I mean, to be fair, always the person with the biggest channel is always last. Don't you know? I mean,
Pondering's probably got the biggest channel of us. He's here. He was here.
Then I don't know. He's breaking the mold.
That's right, guys. I'm revamping it. I'm changing it. But to be fair, he's shitty. Like, Steven is shitty with time, period. He'll tell you that. I mean, he is genuinely.
There's something to be said, though. If more people want your time, it's usually harder to be on time, right? So if you're someone who everyone's trying to line up to debate, then yeah, it's probably you got 5 things going on. Like, for example, Gibbs and me have another panel after this. Theoretically, if this runs a little late and then we have to go to the bathroom or something, we might be a little late there. You can't really blame us.
You double book for panels?
Normally, no, but here's what happened. Last week, we were supposed to do Lethwater. Is that how you say it? Lethwater Kai's panel?
Yeah, Lethwater.
And then without me knowing, somewhere in the middle, they were like, hey, we pushed it off to next week. So I put my video title up and I'm ready to stream. I'm ready to debate. And then people were like, hey, Rob's stream title says it's tonight, but it's next Wednesday, right? By that point, I already told Wick I would do this panel. So then at that point, I didn't want to lie to Lethwater Kai because I told him I'd do that panel. And I already told Wick I'd do this, but it ended up working out that they didn't overlap. So I didn't have to tell someone I couldn't do it. So, but this is it. I'm done streaming for the week after this. It's been a crazy work week. So this will be it for me. So
I think it's gonna be pretty good. It's gonna be real spicy, I think.
Yeah, we'll end strong. We'll end you for strong. Me and the Lethwater Kai will get you.
That stream's gonna be worse. Or it's gonna be spicier than this one, at least for me.
I like people are like real butthurt already. Like it's gonna be exciting. It's gonna be good.
I'm gonna try to keep it calm here and discuss facts in this one, unless Pisco wants to,
no, I'm
talk personal or whatever. But I'm calling Connor and Tiberius out. And also, I feel like
they're gonna be on this stream.
No, the next one. They're on the next panel with us. And I feel like righties could take it better than lefties. So I could call them all kinds of names. Yeah. Well, are they righties? That's the question, right? Hey, Rashad, I know we've met, but we haven't talked much. Nice to talk with you.
Yo, what's up, Rob? Nice to be here again. To debate you. I feel like you're like the final boss of like Republicans in this space, like or at least conservative. So it's always good to get an actual challenge.
Yeah, it'll be fun. I think it's gonna be a good one.
Are you going on Tim Pool again?
Blacktoid's actually the last person.
Did you call him Black Toy?
Well, he's embracing dangerous behavior. Wearing Hawaiian shirts, driving motorcycles.
Rashad's trying to get us canceled here.
Yeah, please. I'm on YouTube, man, and listen, I'm trying to take this as far as I can. So Gibbs, please, for the love of God, don't get me canceled. Yeah.
Well, I don't ever cross TOS. You go pretty close, and then we stop.
Holy shit! Okay. Well, I've never seen Lactoid. I thought that was Pisco. I was like, man, you've really changed your face there. But now I see what's going on.
Okay. Kings. We're gonna start on time. You guys know the drill. I'll introduce a topic. I'll say hi to my guest, and then we'll start the show. Any questions before we go live?
What are we thinking for opening statements? How long?
If it's a minute. Stop, right? Like, very concise, please. I want to get to the meat of the discussion. Give me one moment. Okay. Let's go. Welcome, one and all, to yet another episode of Wick TV. a cross-ideological space where we come together to talk about issues both political and cultural, from the silly to the serious. Gang, have we got a show for you tonight? Last week, former President Donald J. Trump was found guilty by a court of law on 34 felony counts. Was this evidence that the court system is working as intended? No one is above the law. Even the highest people in the land, the richest people, are still subject to the rule of order? Or, as some claim, is this evidence that the justice system has been corrupted by political machinations in order to prosecute and persecute people's political opponents and enemies? We've got some great perspectives here tonight to talk about this, and we're going to get right into it. I want to give each of these individuals an opening statement, a chance to introduce themselves, to tell people where they can find them, and also a concise, and I stress this, concise, opening thoughts on the subject at hand. I have a list of questions we'll get to if we can, but basically we're going to be talking about if this is justice, if the Trump verdict was has merit, and stuff like that. And with that, let's start by passing it off to Gibbs. Go ahead, start us off.
Did that glitch
Hey,
out?
I'm Admiral Gibbs. You can find me at twitch.tv/Admiral Gibbs, and all my
Did that
other
glitch out for
socials
you
will
all?
be the same thing, Admiral Gibbs. Let me tell you, this trial was a travesty and an utter disgrace. It was a complete farce. I didn't know we were living in a banana republic where kangaroo courts used to persecute your political opponents was now a thing. But guess what? It's 2024, and Sleepy Joe and the Dems have decided they can't beat Trump in the election fairly, so they're gonna rig the courts against him. Whenever your best two witnesses are a hooker and Michael Cohen, a known perjurer, you don't got much. You guess you got to make up some crimes.
Okay, well, thank you for that. I'm sure we'll get
Yeah, I'm
into
trying
it.
to figure out why these things glitch
Next
out.
up, Josiah from Pondering Politics, please.
Hey, everybody, this is Josiah. I host Pondering Politics, a liberal/progressive YouTube channel. Good to be chatting with some of my good buddies and some of my favorite frenemies. Yeah, long story short, I'm glad I had Pisco here to argue the legal merits of it against another attorney. As far as the general proposition, I think that it's perfectly acceptable to prosecute powerful people, Democrat or Republican. I think it's actually a banana republic to not prosecute powerful people. As best I can tell, these were technical violations of the law under New York law. I have no doubt that Alvin Bragg wanted to get Donald Trump. I don't know if he actually campaigned on it like Letitia James did. But also, we've seen violations of that sort of norm for years. Donald Trump publicly campaigned on jailing his political opponents. Conservatives didn't care. They cheered him on. They actually wish he would have been more successful. So there might be a case for toning down the rhetoric associated with these things. I do think that would be appropriate. But yeah, Trump is entitled to the presumption of innocence. He wasn't able to make his case. He has the right to appeal. This may be overturned on appeal. And again, I'll accept the results of that as well. But I'm looking forward to having the conversation. And again, you can find me at youtube.com/@ponderingpolitics.
Well, thanks for being here, and we'll get to it as we do. Lactoid, please.
All right. Can you guys hear me okay?
Yeah.
Loud, but yeah.
Perfect. Okay. So I'm Lactoid. You can find me at Lactoid TV, Twitch, Twitter, and YouTube. My thoughts on this case are, I think there's some general problems actually with applying our normal system of law in situations in which almost unique situations in which I don't know if you can get away from bias. When we compare it to what Trump did, Trump did campaign, however much he denies it. I think he did campaign with
hey,
the
Steve.
situation.
Hey,
but
everybody.
Even he said, we're going to get independent counsel to look into your business, if I recall is what he said. It's a little bit different when you have the guy who runs on process, getting you, also being the prosecutor, right? Being the person there who's kind of directing things. I think it's a little bit different. I think the judge in this case had some, in the past, had violated some ethics codes, demonstrating some bias. And I think the jury, it's difficult in this case for me to believe that the jury was truly unbiased here. Legally, I think there's a lot of problems with the case. And I think that there's enough here for an appellate court and potentially the Supreme Court to look into it. And it wouldn't surprise me if this gets overturned. It also wouldn't surprise me if the judge tries to give Trump jail time. And if that happens, that's going to be kind of a novel situation.
Kevin,
Okay,
this
well,
could
thanks for
be, I
being here,
expect
and
it's
I
going to
hope
be a
we will get
2-hour
into it.
debate.
Next up, Pisco, please.
Thanks so much, and thanks for having me. I'm Pisco Liddy on Twitter, X, whatever you want to call it. This case was about corrupting, or Trump's attempt to corrupt, the 2016 election. And the evidence really and the facts in the case are overwhelming that point to his guilt. I expect today we're not going to be talking so much about the facts, which prove demonstrably that this was a series of 34
I don't think Bragg
false
campaigned
business
on getting
records.
Trump. I have
At
no
this
doubt
point,
that
I
he
think it's
wanted to,
self-discrediting
right?
to
But
deny
no,
that
I
these
don't
were
think he campaigned on it. I
reimbursements
know he
as
said
opposed to
after he was
structured,
elected
fake,
that he would
legal
pursue the
payments that never,
investigation.
ever
But I
existed.
believe there were
And
already
so,
probes into
be,
Trump at
like,
the time that he
aware and
basically
conscious and looking
inherited.
out for how many
And then he
actual
said he was going to
arguments you
make it a
hear about the underlying
priority.
facts in the matter.
That's,
The
I think,
campaign
acceptable.
purpose is a
Letitia James,
foregone
the New York
conclusion
Attorney
looking at
General, she
all the
did campaign
evidence
on getting Trump, and I
demonstrating
do
beyond
think
a
that's
reasonable doubt
inappropriate
that these
for
payments were
any
specifically for the purpose
potential
of promoting
prosecutor,
Trump's
attorney general to
candidacy.
publicly
On the
campaign on
legal
prosecuting a
issues and legal
particular
errors
person.
that may arise,
But again,
I don't
Trump did it
deny
too. And
that there
also, on
could
the
be
other hand,
some
Trump had a
appellate, there will be
long-standing
appellate practice
history
to
of
see
and
if we can get
reputation
the
of corruption in New
overturned. I
York. He
don't
was one of the most
expect
sued people in the
those
country.
convictions,
So I
sorry,
think you
those
could also
appeals to
make
be
a case that's
successful.
more understandable
It
for
could
James. But
happen,
again,
I
as a
just,
general
on
proposition,
the
I don't think
merits
it's
of the
acceptable.
operable legal issues, I think that the people have a better of the case, and I'll be interested to hear Lactoid's description of those issues and why it should be overturned. I don't think there's any point in sort of undermining the jury in this case.
Also, how's the
absolutely
volume?
Zero evidence of jury bias, and so I don't even think that we should go there. But yeah, that's my thoughts on the case. It's absolutely a deliverance and justice.
Well, thank you for being here, and I'm sure we'll get into the merits as we go. Next up, Rashad Crenshaw, please. What do you got?
Trump is guilty. Amen.
Okay, short and sweet. Well, thank you for being here. We'll see where it goes. Last but certainly not least, Rob Noor. Go ahead.
Yeah, Rob Noor, Normal America with Rob Noor on YouTube, Rob Noor everywhere else, spelled Noerr. So what this is an example of the political persecution that Trump's been facing since he came down that escalator. Chuck Schumer told us all that he couldn't even criticize the FBI because they would find 6 ways of getting back at him. The Democrats, to anyone who's reasonably objective, can see that they have scrutinized and tried to investigate and
Just let me know throughout the conversation if a particular person is too loud, and I can like adjust their volume in Discord. I'll keep an eye on the chat for loudness.
we have prosecuted and convicted as a felon a former president and the frontrunner of the current party in power, the frontrunner going against them in the future election. This is brazen election interference. And what's the crime? Well, it interfered in the election because you had the right to hear about him having sex with Stormy Daniels. This is done by the same party who colluded with the media and had 51 former intel agencies tell you right before the election the Hunter Biden laptop story that showed evidence of the corruption of the Biden family was disinformation and needed to be censored. The Democrats are literally making this argument today that we need to lock Trump up for interfering in the election because we needed to know about his sex life. But almost every institution in this country colluding to censor stories critical of Joe Biden going into the 2020 election. Well, that's okay. It was just a whoopsie. There are 3 layers to look at this case. The first was it a political prosecution? Would this have been brought against anyone else if it wasn't Trump? And is it worth taking this process crime of just a paperwork error and having that be the first felony to go after? What's the precedent that this sets going forward? The second is the issues with the crimes themselves, due process violations, etc., which we could get in. If both of those barriers are passed, then you get to questions of, was Trump guilty? But if it's a political persecution, which I think it is, then there shouldn't have been a trial. If the case law, and the due process violations occurred, then he shouldn't be guilty. And lastly, if you get through all that, we could talk about the specifics. Now, I will admit, and I hope everyone else here will as well, we didn't read 4,000 pages of transcript. I don't think any of us have done that. So it's difficult to say exactly with veracity what each witness was saying the entire time. So I'm not going to spend a lot of time on that. But if that's where other people want to take it, just keep in mind, I think we could all admit here, none of us have read all of it.
Okay. Well, thank you for being here. I guess first question, right? Should these charges have been brought up? Is it normal? Is it a common thing, or even just an uncommon thing, but still within the realm of possibility for these types of charges to be brought against someone in a New York court? What do we think? Go ahead.
So two different questions. One is it normal to do this, these kinds of charges in the way they were done, and should the charges have been brought? Those are different questions.
Right. So you want to
Pick
answer?
one, right?
Yeah.
Pick one,
So
yeah.
to answer both, in
It's
terms of
definitely not common.
the underlying crimes at issue here, tax fraud, campaign finance violations, business record crimes, those are not novel. Those happen as a routine matter for the Justice Department with respect to the campaign finance portion and the tax portion. And of course, the business records is bread and butter of the DA in Manhattan. This particular theory is novel in terms of the New York election law being applied as the kind of underlying aspect to the business records exception, but the underlying fact pattern here is not novel at all. The misconduct here is not novel at all. It all goes to the heart of really core aspects of our democracy that the people voted on, which is our election laws and obviously our tax laws and business records laws.
Can I just say real quick? I'm sorry. I have a question real quick. I read somewhere that there was, I think it was like nearly 10,000 cases that was that true that there was like a figure that 10,000 cases have been prosecuted in New York since 2015 under these statutes? Did I get that figure wrong? Does anybody know what I'm talking about?
What you're talking about is the general numbers of people that have been prosecuted for the crime of falsifying business records.
Gotcha. Okay, thank you.
So that is true. That's common for New York and other states to prosecute falsification of business records. Here's the things that are uncommon. Anyone could answer this if they think that I'm wrong about this. So I'll ask them questions. It was a misdemeanor, just so everyone knows, it was a misdemeanor. Here's how it worked in general. Because it was a misdemeanor and the statute of limitations ran out, they decided to charge him with the felony of falsifying records, which means okay, go ahead.
You said because the statute of limitations had run out, then they decided to do that.
That's exactly right.
As though it were causally related, and there's absolutely zero evidence that that the statute of limitations was driving the felony upgrade as opposed to the underlying misconduct. So that's why
it was. He's absolutely wrong. What happened is they wanted to get Trump by any means necessary. They wanted to get him for this falsification of business records. Statute of limitations ran out, so they decided to have this novel theory.
No evidence for that.
The reason as to why I'll contest it. Hold on. I'll contest this.
One at a time.
Mm-hmm.
I want to make sure that Rob gets a chance to finish, and then I'll let you contest it, Rashad. And just before I forget, because I almost did, I do get a check from Progressive Victory, just full disclosure there, and I think Josiah does too. But yeah, anyway, go ahead. Finish.
Now, I understand that the lefties want this to be a lefty back and forth panel and want to filibuster and try to distract people as they're talking. I'll get my point done, hell or high water. So that is exactly what they did. And so if you look at this, just a brief outline of what the case is. It's now a felony to falsify records, but it has to be in the commission of another crime. That crime is 1715-2, which is basically a conspiracy to basically influence the election by promoting a candidate or by going against a candidate by unlawful means. So then the third level is there had to be an unlawful means. Those unlawful means are, one, the circular logic of falsifying records. So you falsified records, which was a misdemeanor, but we're saying it's a felony, and one of the ways you did it was by falsifying records.
There's no circularity
The second,
there.
Please,
If you
Pisco, I know it's difficult for you to follow decorum.
But you're lying in every step of it.
So I know that's difficult for you, and you're mad because you got blown out and your feelings were hurt on Twitter. I understand that.
So we can skip this part. We can get to the thing because we do need to be concise in our statements.
That's true. We do need to be concise. So what I would like, it would be nice to be concise, Wick. So maybe as a moderator, you could ask him to let me finish my point before he would interject. I think we gave the left a chance to start. They were talking to each other. I think it would be fair if I get to finish my point without him interjecting at least 4 times. Is that fair?
I'm giving you the floor. You have the floor.
Thank you. All right. So that's now where was I with my train of thought? That was one. The tax violation was Trump falsified records to pay more in taxes.
Remember, you have an audience. Thanks, Air Bloom. I'm trying to listen and do this at the same time.
You aren't.
You have to mute yourself on Discord.
Sorry, we can hear you.
Buddy.
Thank you. Sorry, buddy. Sorry, Rob. God damn it.
Okay.
Can you hear me now?
The second unlawful means. Now, the audience has no idea what's going on. It's trying to overview this, but thanks to the constant interruptions. But that's indicative of the left. They don't want the facts to actually come out. So the second was that he falsified tax records that resulted in him paying more in taxes. How common is that? To charge tax violations where people paid more in taxes than they were supposed to. Go ahead.
Is that rhetorical, or do you want me to not?
No, I'm asking. Can you give me the case on that?
Yeah. So if you know anything about like money laundering or aspects in which you are pretending that something is payroll taxes for purposes of evading things, that is not uncommon. It's not unheard of. And for you to pretend as though that it shouldn't be a crime for you to knowingly falsify the 1099, I just don't know what you're talking about. You could be doing all kinds of nefarious things by.
He can't give me a case on it. He can't.
Hang on a second. just to be 1,000,000,000,000%
He can't
clear,
give you one.
if I were able to provide you a case in which overpayment of taxes was actually prosecuted, would you say that everything you're having to say about that being abnormal is wrong and that you're
No.
sorry?
If you could find one,
then why are you
if you
asking me
listen,
for a case law if it
if
won't
you-
convince you? Rob?
if you would listen, that doesn't mean it's normal. There could be something that happened once or twice. Pisco, is your argument that if a case was done once, that it's normal? Is that your argument?
No, but you asked me
Oh,
for
thank you
a.
very much.
Hang on. You asked me
Thank
for
you.
a
That's what I thought.
case.
That's
You
what I
asked me for a case, and what you just admitted was if I could present it to you right this moment, right this second, you wouldn't accept it, and it would not be
That's
evidence
not what
of
I
anything.
said. That's not what I said at
Yeah,
all.
that's what
I
it's-
know
yeah.
that is not what I said at all. What I said was that wouldn't be proof that it's normal. The fact that I asked for case law was showing that you seem to be so confident this was something that's normal that you'd be able to shortly cite some cases. You've been looking into this, and the fact that you can't even do that further exemplifies how this wasn't normal. Also, can you name me a case
Hang
where
on a
the
second. How do you
falsification
know
of
I'm not
records?
Hold
setting
on,
you
hold on.
up?
Hey, we do gotta let other people respond. So let's stick
Last
to this
time
point.
last thing.
Last thing you got to be quick.
Can you name me a case where 1752 was used to go after someone for falsification of records?
I can't name you a case when 17152 was used to go after someone for business records.
It's never happened. And I don't know why Pisco can't just admit that all of these things are exceedingly rare or have never happened. Even prosecutors that are saying, or legal experts that are saying that Trump should have been charged and should have been found guilty, admit that this was something that was novel.
We got to get to other people. Rashad has been wanting to go, and then I want to hear from Lactoid, and yeah, we'll get into it. Go
Oh no,
ahead,
we've
Rashad.
already veered off from what I was gonna say, so I'm organizing my next move here.
Well, he just
Lactoid.
said a bunch of things unrebutted. I would like to respond to them if that's okay. Unless
Sure,
you want
yeah,
to
okay. Well, I want to make sure Lactoid has a chance,
go
and
for
then Pisco, you're absolutely after Lactoid. Lactoid, go ahead.
Okay, so I don't really know, in terms of actually getting into the meat of this, I don't really know where we should start, so I'm just going to talk about whether or not it, like the elements that make it a felony, because without that, there's no case at all, because the statute of limitations on the misdemeanors did run out. So my understanding is the three theories here are going to be the election, basically election fraud, business records violations, and then tax fraud. Specifically with the tax fraud, because that was just being talked about. My understanding is 175.10 requires a intent to commit another crime. I can see how in certain circumstances, perhaps, how you could, like if you're trying to launder money, for example, how you could intend to commit tax fraud, because that would be the reasonable thing to do, given like your goal of trying to launder money. And if evidence of that is demonstrated at trial, then perhaps it could be reasonable that that was your.
What was the name of the statute, that 17592? What was it that they were referencing? Can you guys type what it was?
To commit tax fraud, that he had the mens rea to commit tax fraud. What was his purpose in overpaying taxes? What was the intention of overpaying taxes? How would that help him?
Pisco's an
It's a
attorney.
really
Pisco
good
and
question, and one
Lactoid
that
are
I'd like to
attorneys.
answer.
Pisco's on
So,
our team.
the
Lactoid's
whole
on the
reason
opposing team.
Why this is a falsified business records, the underlying false records, have to do with mischaracterizing Michael Cohen's the payments given to Michael Cohen.
That's why I'm
in
going to
year
let Pisco do the vast
2017
majority of
as
this,
income,
because it's
as
more of a
opposed to
legal. These
reimbursement.
questions are more of a
As those of you
legal
who, like,
thing
work
than
in
anything
HR
else. Now, if
or
they want to
taxes
talk about
understand,
actually
when there's a
prosecuting
reimbursement for
political
expenses paid,
opponents
there's no
and you
tax
know
there,
the political
right?
implications
So
of
you're gonna have
that,
to
then
ask
that's
yourself
more my
one
wheelhouse.
question first is, well, why would Donald Trump, first of all, structure a reimbursement payment, which is beyond all doubt, and you guys aren't even contesting it, and if you do, you're going to look foolish. Why would he structure this in 11 payments for $35,000 each? Why would he do that to pay taxes? What would be the purpose of doing that in gross net for taxes if he could just make one payment for $180,000 and not have to pay those taxes? There's a reason why they structured it as income, right? The very question you asked
Restream to
gets
stream,
you the
and I'm on
answer.
Discord
The
for this
reason they
debate,
structured
and
it as income was to
again,
hide
I
the
probably should just be
reimbursement
using
aspect of it.
OBS or something
By
else to
hiding the
simulstream, but
reimbursement
it's
aspect
easy to
it,
just pop
they
in and
hide
do
the
this
fact that a
shit.
payment was made to Stormy Daniels in 2016
Thanks, old Scotty.
and wasn't reported and was an illegal campaign contribution. So your question, why would he do this? It's a great question. The reason is to hide the election interference.
So I understand the theory as to like your theory you're presenting as to why he would do this, but my understanding is that you have to do this with the intent to defraud and to commit another crime. That's how the language of the statute, of the underlying misdemeanor statute. And so if the underlying crime here is to, like, the underlying intention is to commit tax fraud,
Yeah,
is
they
there
knew
any?
they know that those are false.
Well, hold on.
So-
Is there any indication that like Trump did this with the intention of like,
Yes.
I'm going to cheat the tax code to pay more taxes?
If you read, sorry, not listen. I do also agree with Rob that there should have been video cameras there. So I on that point, I think it's a good point. There should have been video cameras. But if you read the testimony of David Pecker, he says David Pecker, Michael Cohen, Donald Trump in a room together, all talking about how Michael Cohen was going to receive the payment. Cohen says, I want this as a lump sum payment. Give me it as a lump sum payment. They're like, no. Let's structure it. Let's make it so it looks, as a retainer agreement that never existed for legal services that were never performed. All of this was fake. And the reason it's fake and the reason why they're paying double, you think Donald Trump's going to pay double what Michael Cohen is owed? That's just bullshit. The reason was they were trying to hide.
Washington Post article I'm looking at says that this particular statute, 17152, is seldom prosecuted. Washington Post says a search of the New York State Law Reporting Bureau for relevant case law dating back to 2000, so 24 years, found 2 entries in which a judge issued legal opinions. So it does seem to be relatively rare, if not literally novel.
Here, it's not necessarily about the commission of a crime, right? This is what the lefties have been saying on Twitter. It's not about the commission of a crime, which is arguably correct. It's about the intent to commit a crime.
Yes, no, I'm
so yeah. So did Trump?
You don't need to record. You don't need to record that says I know that I'm breaking the law. I don't know where you got that note.
So hold on, but is there any reasonable interpretation here that Trump intended, like he was intentionally trying to break tax law, like he wanted to break the tax law?
Are you talking about the standard for willfulness, where you're knowingly breaking the law as opposed to knowingly doing the act that constitutes an illegal act? Because as I understand it, because we have a prosecution right now for Hunter Biden for tax fraud.
I understand why they didn't cover this with live video, but it should have been videotaped for the public. Honestly, I don't see, for every argument I see against videotaping or recording trials, to me, it's blown out of the water by reasons too. Like Supreme Court hearings should be video recorded, not merely audio recorded. But to your point, yeah, if they don't want to prejudice people or whatever for any reason, they can not live report it. But I do think there needs to be a video record. I completely agree.
That sort of the mens rea was, well, the reason that he intended to commit this tax fraud goes back to FECA, goes back to the federal election issue. So didn't you say that his reason was that he wanted to bury the payments to violate the federal election?
No. So that's the motive, but you don't need the motive to prove the tax law, the violation of taxes. The violation of taxes is he called something that was income not income.
But that's not intent.
Sorry, something that was not income. Yeah, wait, hang on a second. If you go on your form and you say, I was paid $500,000 in income by X company, and that is a knowing and intentional lie, and you submit that form to the IRS, do you think that that's a crime, yes or no?
No.
You don't think it's a crime to
I'm sorry.
consciously lie on a tax filing?
Let me. It is a crime probably in the sense of that specific legal statute, but it is not proof of intent to commit the crime.
No, right. Wait, can I kind of elaborate a little more? Like, this is, I think, maybe the disconnect. Where, like, generally I agree with you. Ignorance of the law is not necessarily an excuse when you break the law. Right? Yeah, I get that. But what I'm saying is, in this case, this statute, in order to rise it up to a felony, requires that you had the intent to commit another crime.
Right.
And so now the question is, if you're not going to specify the underlying crime, how I read that is you had to intend to commit a crime. And in this case, if it's tax fraud, you have to prove that he intended to commit tax fraud.
But tax fraud just...
Yes, it's just one of the three. That's correct.
It's just one of the three. So even still, you can still...
I have arguments against the other two as well, though.
Wait, Lactoid is wrong about the law. What he's suggesting to you is that Donald Trump, in order to be guilty of the election statute, he needs to actually know what the tax code is, or know that he's violating it, or know that what the Federal Election Campaign Act says, and know that he's violating it in order to be found guilty of the crime. And he just told you the normal rule is ignorance of the law is not enough. If you know, for example, that Donald Trump knowingly made a payment, let's say an illegal campaign contribution in 2016, let's imagine, right? And he was ignorant of the law. Do you think that would be an excuse?
If the statute specifically provided that he had to have intent to commit another crime, it potentially could be. Do you think, Pisco, that if he was told that this was legal, let's say, and he had no reason to believe and he had no idea whatsoever that that this was like allegedly tax fraud, arguably tax fraud.
Dude,
Do you think at that point? Do you think at that point that he falsified the records with the intent to commit tax fraud if he had no idea that it was tax fraud? How could you possibly prove that he had intent to commit tax fraud if he had no idea if it was tax fraud?
I reject your premise on two levels. One, the premise legally that you would need to have a specific knowledge of breaking the law. That's usually implied by the term willful. Willful is the usual rule when you need to know you broke the law. The example of that is the Robert Hur report, where willfulness is required for the Espionage Act offenses. So I reject that premise, number one. But even as applied, Donald Trump is a billionaire. He looks meticulously at his business records, as was testified to by his accountants, by people within the Trump organization. Donald Trump is aware, even if this were the standard, that you can't lie to the IRS about the information you're giving them. That's ludicrous.
I'd like to, Lactoid, if I may, if he was so hyper focused on his finances, how did Cohen manage to steal $60,000 from him in these payments?
Do you believe that Michael Cohen stole $60,000 from him?
Yes, he testified to it.
Okay, so you believe this was a reimbursement, right?
Yeah.
You believe this is a reimbursement?
No. Okay.
You agree that so just number one, you agree these are falsified records, yes or no, Rob?
No.
You just said that Michael Cohen stole $60,000. Michael Cohen only stole $60,000 if you believe that this was a reimbursement. So I'll ask again. Do you believe these are false records, yes or no?
I don't believe, let me clarify my answer. I don't believe that Donald Trump paid attention enough to...
Josh Berry, that is dumb. Just because someone is rich does not mean they're meticulous. Yeah, but what Pisco is saying is that it was testified to by those who know Trump that Trump is meticulous. So there was witness testimony that, hey, our boss, Donald Trump, was very meticulous in terms of his finances. I agree. Just being rich isn't proof of it, but witness testimony says the opposite.
I would like to go back to Pisco. I would like to go back.
What just happened?
So
Rob Moore just
going to go ahead and
hold on. Both of you stop. I want Pisco to finish. We let Rob, let you finish. Let's let Pisco finish, and then we can.
Rob just admitted, because he said Michael Cohen stole $60,000. Michael Cohen, that theory only works if you agree that it's a reimbursement. And then Rob said, I agree that it probably was a reimbursement. That's the direct opposite to what Donald Trump was arguing in court in this trial, because he was trying to say these weren't falsified records. But what Rob just told you inevitably leads to the conclusion we all know this was a reimbursement, and therefore these records were false. The only thing left is the purpose.
Okay, and notice how Pisco avoids the questions, what he does. So he intuits that Trump knows so much, he's meticulous in looking at his records, etc.
Yeah, so I'm trying to follow along here, and where I think the disconnect is, so there's like 3 levels to this. Number one, the first level is the falsified records. The second level elevates that misdemeanor to a felony if it's proven that the defendant falsified records with intent to defraud that includes an intent to commit another crime or conceal the commission thereof. Lactoid and Rob seem to be thinking that that means you have to prove Trump had the intent to violate the federal election law, but that's actually skipping a step. The second level, the second other crime is conspiring to promote or prevent the election of any person to public office. So Trump falsified record with the intent to promote the election of any person to public office by unlawful means. And then the unlawful means is potentially one of 3, violating federal election law. So I think they're skipping a step. But I'm not an attorney. That's why I fucking hesitate to weigh in on that, because Lactoid and Pisco are attorneys going back and forth, but I think Lactoid was missing a step, and that's why intent doesn't matter.
At 130 years, because instead of saying reimbursement, he said that it was an expenditure, or I'm sorry, it was a retainer fee that he was paying him an income, which is absurd because it all goes back to the general theory of it has to be tantamount to a conspiracy to affect the election. The problem is this wasn't a crime to affect the election, because these sorts of things would have happened irregardless if he was running for office, as is evidenced by the fact that Trump's had NDAs in the past.
I want to make sure that Pisco gets a chance to respond, but then we got to open this up because Gibbs and Josiah, I don't know You're having a grand old
I
conversation.
also got to say one final thing on the tax thing because I
Okay,
can
yeah, but
explain it
Pisco
differently.
gets to respond. Then yeah, we'll open it.
Yeah,
up.
so just to respond to that real quick, I mean, there is no, like, if you understand how to file taxes at all, you surely understand that knowingly lying on the form, not about like smiley face or whatever it is that you know, this is Rob's favorite game, shell game, where he wants to give you kind of maybe like a on the margin kind of fact pattern where it's not 100% clear, and then that, you know, automatically delegitimize every single tax prosecution in history because you can find one edge case where I'm not sure, and that's when he attacks. It's a shell game. It's a losing strategy. People understand if you knowingly and materially and falsely lie in your taxes and produce and pay, you know, payroll taxes on fake income for legal services that were never rendered, that's a crime. And
can I ask you real quick? Is it a crime if it doesn't materially affect either side's tax payments?
So it is a crime to materially lie on your tax forms.
Even if it doesn't affect how much money the government gets from either party.
Of course, it's still a crime, Rob. Of course, it's still a crime. So to be 100,000 trillion% clear, this was a crime. Submitting fake income to the IRS was a crime. Now, Rob says, well, this is kind of a minor thing, minor, you know, tax, whatever. Who cares about tax fraud? Query Hunter Biden for a second, just put that to the side. But more to the point, it's not about that. The point is it was hidden for a purpose, and that purpose was to mess with the 2016 election. That was the purpose.
Can I ask a quick question?
I got to say one last thing on the tax thing. I have to.
It's about the tax thing that I want to ask, just FYI, between you two, because I'm trying to suss this out in real time. So when you're done, I do have a question about it.
Okay, just real quick. So the mistake that's being made is Pisco is saying, well, willing is a different standard here, right? Which I understand. And if they were charging Trump with tax violations, perhaps they wouldn't have to prove a requisite state of mind, right? Because he may have committed the crime. But in this case, the crime is the misrepresentations of the business records, like the falsification of the business records. And so the question is, when he was falsifying those business records, did he do that with the intent to commit tax fraud? That's what needs to be proven. Not that tax fraud happened, that he falsified with the intent to commit tax fraud. And what Pisco is saying is, no, he did it with the intent to hide the payments.
Okay.
Wait, so let me get this straight. You can commit tax.
Yeah, so
Aya gets to go.
So here's my question for the two lawyers, because now I'm confused. I thought there was basically 3 levels to this. Number 1, he falsified business records, a misdemeanor. It's elevated to a felony if it's in furtherance of another crime. The prosecution says that other crime is not the FICA violation. It's conspiring to promote someone by unlawful means in an election. Yeah. And then...
It's not in furtherance of another crime. It's intent to commit another crime. That's an important distinction.
Or conceal.
Or to conceal the commitment of another crime.
Or conceal, but intent's required.
Right, or conspire. Well, that's where I'm... So... I thought the third level was where the FICA violation, the potential FICA violation, was 1 of 3. So where does the specific intent to violate FICA play a role? That's where I'm confused on this with you two going back and forth.
It doesn't. I mean, he's confusing the willfulness standard and pretending that. I mean, all I have to say is to respond to Lactoid is, do you think that Trump had to know his particular, the ins and outs of the tax law or the tax code in order to be and know specifically? Let's say that he just wasn't sure. He was 80% sure that maybe it violated the tax code. I don't think that is a fair reading of the statute or the law, and that's not what the jury instructions say. They don't say that you need to specifically know. But even if it did, and even if I'm wrong about that, I could be wrong about that. Trump is a sophisticated business person. He understands that he has to pay tax. He understands the basics. You can't lie about it. And so it's obvious.
If I may. So first off, Pisco has the exact opposite description of this as he did with something like Hillary Clinton mishandling classified information. When she said she didn't understand classification markers, and people said that beggars belief. In fact, one of the FBI agents that was investigating said it defied credulity that she didn't understand that because of her profession, because she had been in Washington for so long. And Pisco said, no, none of that matter. It didn't prove intent. And you said, but Pisco, she'd sat through these briefings over and over about classified information in the proper way. No, none of that mattered. Now he's like, well, Trump's a businessman, so clearly Trump knows the ins and outs of exactly the tax law and how it works. Now, to answer his question specifically, if intent to commit another crime is necessary on step 1, falsification of business records with the intent to commit a secondary crime, that secondary crime says to commit that crime, you needed unlawful means. That means that the intent is also necessary for that third level of the unlawful means. Because if you intended to commit a crime, that means you have to know it was a crime. And if you didn't know it was a crime, then you didn't commit the secondary level of crime. So the idea that Pisco's trying to tell you that Trump intended to commit a crime to pay more in taxes, and then he furtherance goes on to say as follows. He says, even if you don't materially affect the taxes of either party, it's still a crime. So what Pisco's saying is tantamount to this. For the first time in history, we're going after the frontrunner for president from his political opposition and a former president in tantamount for what this would be a crime. Let's say I write off my business space for streaming as a 50 by 50 space, but actually it's a 50 by 500 space. So I actually could write off less. I lose money. I'll pay more in taxes because I materially was wrong about the size of my space. Pisco says that that's a crime. Correct, Pisco? Because I lied on my taxes, correct?
You knowingly and intentionally lie on your taxes and misrepresent to the IRS. That is a crime. I don't know why you think it shouldn't be a crime. You can talk about prosecutorial discretion about whether we'd go after them. That's fine. I have a lot more to respond to you, but I want to give you the floor because I know that you were in the middle of something.
No, that's it. No, that's fair.
I think it was done. Yeah.
My response.
Hold on.
One of the Hillary Clinton. Who said hold on? I can hold on.
Rashad.
No, you keep going. You keep going.
One is this fatuous comparison with Hillary Clinton. There are a lot of problems with evidence in that case, including the fact that they can never prove that Hillary Clinton saw these not big classified headers that were in Biden's documents or that were in Trump's documents, but like little bracket C's that were embedded within emails. You can't prove that she ever saw that, number one. Number two,
she admitted it, so that's okay.
Hang on a second. You can't prove that she ever saw.
She admitted it.
I don't believe that, but if it's
she did, she said she thought it meant alphabetical order. She admitted.
Wait. Admitting, thinking that the C's, when shown them, means something is different than at the time where those were mishandled. Having been able to see the emails.
No, you said she didn't.
Hold on. Hey, both of you stop. We're not going to litigate the Clinton stuff here.
I understand that. I just want to be 100% clear that being shown an email by an investigator is different than contemporaneous knowledge of those emails and their existence. And so that is going to be difficult to prove in a prosecution. There are a lot of other evidentiary problems that we're not going to relitigate. As for the specific intent, no one is saying that you can do this by an accident or you can do this by carelessness. You need to intentionally lie. There's the mens rea components are still there, and all of these elements with intent, as was told to you by Lactoid, ignorance of the law is not a defense. Typically, that's an unusual statute.
Typically, not here.
Hang on a second. For attempt liability, ignorance of a crime is not an excuse. Typically. I just want to be 100% clear with you.
That's not true.
It is true. It is true.
Now listen, it is not true in the way you're implying it here. If intent is necessary, if you didn't know that it was against the law to do something, then you didn't have intent to break the law.
No, I mean, I don't know why you're lecturing me right now about attempt liability. The normal rule is ignorance is not a defense of the crime. And Lactoid will tell you right now, because he's taking crim law, that attempt liability does not require knowledge or ignorance of the law. It's just not the case. If you rob and say, well, I didn't know what the robbery statute was, or I didn't know this was grand larceny, Lactoid is going to tell you that that is not an excuse or defense of the crime. It is the unusual statute that requires knowledge, actual knowledge of the law, and that you're breaking the law. That is not the normal rule. And the final thing I'll say, and then I'll hand it over back, is Rob acts like this is like some great unprecedented thing. You're going after, political rivals. After this indictment was announced in March of 2023, Rob welcomed this. Rob said, I'm glad that we're doing this tit for tat. I think that this particular case is corrupt, but I have no problem going after politicians and going after powerful people. He said, yeah, let's go after Hillary Clinton, let's go after those people. And so I don't have a problem with the precedent. He criticized MAGA people for saying that the underlying political nature of it and that they should be immune. He said that was bad. But now when he realizes that, what the marching orders are from MAGA universe to call this about democracy.
Dakota, where have I been talking over people? I'm doing it right now because you keep saying that I'm doing it. I have been quiet for the past 15 minutes.
entire political worldview is orange man bad, and so they're willing to sacrifice all their principles to go after him. I'm not really attached to Donald Trump. I think that 95% of our institutional politicians are corrupt. And so, for example, if we're going to go after Paul Manafort for FARA violations, I have no problem with that. The law's on the books, as long as it's equally applied. That's what my argument has always been. The biggest threat to interference in our country is the fact that we have unequal application of the law by intelligence agencies and law enforcement. And so that's what I'm saying. So the fact that they just went after, and we'll talk more about this. We'll talk more about sort of if it's being equally applied. But yes, I have no problem if Donald Trump is being charged.
Calrus, that was like 30 minutes ago. It's my stream. Yes, I have interrupted them, but I have not for the past 20 minutes. And this guy's still complaining about it. That's why I said, if you guys want to watch it elsewhere, go to Wick's stream. This is my stream, and I'm covering Wick's stream. When I have something to say, but I don't want to interrupt these two, I'm going to mute them.
Been frothing at the mouth to get in here, but you both bring up an interesting point: equal application of the law, and I want to touch briefly on that. Right, a lot of people have been throwing out the term lawfare, that this has been weaponized by the Democrats to go after Republicans in a way that would never, quote unquote, happen in the reverse, or happens much more rarely in the reverse. So I want to tackle that question. So this is to Gibbs first and Gibbs' side first. Do you think, regardless of guilt or innocence in Trump's case, whether he was found guilty, whether he was found innocent, do you think that there is evidence of this being a politically motivated and politically lopsided trial? A lot of, for example, one of the pieces of evidence that I have heard is that the judge had been donating to the Biden campaign, etc. Do you think that that matters? And can you put forth evidence that it does? I want to give it to Gibbs first and let you guys respond. Then I want to let the other side can then respond. Gibbs, take it away.
Who here has played beer pong? Have you all played beer pong? Yeah, we've all played beer pong. Do y'all know when y'all go to someone's house and play beer pong and the home team is losing? And so in order for them to win, they make up some baby back bullshit house rule that no one's ever heard of in order to win and say, gotcha. That's what's happening now. It's absolutely lawfare. Let me break this down for anyone who's confused about the exact legal precedent. You have a corrupt DA who openly ran on, I'm going to get Trump. And then he said, somehow, Lord it, landed a judge who has a daughter who is a Democratic operator, and according to MSNBC, raised over $100 million on the fact that her parent was the judge in the trial. That's MSNBC. This is the left-wing news saying this openly. All right? Are you surprised that they're going to create a trumped-up charge to get the Don? This is just disgusting. Look at the trial. They refused to get a change of venue in a district where he ran on this issue, in a district where Trump only got 6% of the vote. Does this seem like a jury of your peers? No, it's absolutely not a jury of his peers. They're not allowing certain Trump witnesses. Then furthermore, the only connection to these documents is literal hooker and a convicted perjurer, which is just basically the legal word for liar, liar, pants on fire. What a surprise. And then it's just an absolute farce. This is shameful and absolutely disgusting that Dems and anyone with a law license would sit here and act like it's anything other than a farce, and sit here and lie to you, the public, with a straight face. You know why Pisco is having so much hard times finding a legal precedent for this? It's because there is none. It's a total made-up bullshit that's just been fugazi'd by the Biden crime family and Hunter Cracky Magoo Biden and the rest of them. All of them just got together in cahoots with Alvin Bragg and this judge and just made a complete mockery of the justice system. It's 100% politically motivated. They couldn't beat him in the campaign. Sleepy Joe's turning into a Roomba and walking off the stage. So they sit here and go, hey, you know how we're going to get him? We're going to come up with 34 things of tax fraud, and then we're going to sit here and raise the statute of limitations by moving it to a felony. It's absolutely political motivation. Okay. I can't believe it's anything that's even a debate.
Okay, I want to let the other side respond, then we're going to give it to Rob.
Okay.
Yeah, good.
Okay. So it doesn't matter if a judge, like the judge is not the prosecutor or the jury. So the judge at the end of the day cannot charge Trump with a crime, and he can't convict Trump of a crime. He can sentence Trump, but at the end of the day, the judge cannot decide these things. Furthermore, when we talk about, it's in New York and people in New York don't like Trump, I'm willing to bet all of your lives. I would never bet mine, but the rest of you in this call, I'd bet all of your lives that Trump's business is probably registered to the state of New York, licensed by the state of New York. The Trump organization is probably registered and licensed there. Where else, if a crime was committed by that organization, would this case take place? Who else is going to be there besides New Yorkers? And as it pertains to the idea that, oh, they can't beat Trump, so they have to pull all this stuff out their asshole, Trump's never won a popular vote. So,
but hold on, it goes beyond that. Like, let's just look at some other things. There's statements from the prosecutors and people in the journalism industry that were there. They go, hey, you know what was weird? The judge was allowing the prosecutor to make jokes to the jury and the peanut gallery like it was open mic night at the comedy club. And then when the Trump defense team wanted to do something, she took an angry tone no matter what they did. This was clearly biased. She gave rigged instructions to the jury. I couldn't come up with that. I mean, I've got a degree and I'm working on a doctorate, and I couldn't understand these fucking bullshit.
Yeah, you know what else you couldn't understand? You know what else you couldn't understand? The evidence in this case. You misrepresented it. You misrepresented the judge. I mean, for one, you said the only evidence we have connecting Trump to all this is a hooker and a liar. You just didn't know anything about the case and the evidence in it.
Absolutely true.
You don't know, for example, that there were many Trump employees that were able to connect Trump specifically to these reimbursements. David Packer from the National Enquirer, Hope Hicks, who loves Trump. Hang on a second. National Enquirer was Trump's friend, and who still likes Trump, who saw Trump, who saw Trump as as someone to look up to, and so you are misrepresenting aspects of this case in terms of the body of evidence, and then you're complaining that it's in New York. I mean, come on. Trump made his living in New York. Trump was made famous by New York. He is a famous New York real estate magnate. And for him to come out and say it's unfair to be in New York, I mean, it was an excellent point from Ashad, although I disagree with him that judges don't matter. Judges are very important. I think that is not true.
Especially when they donate against Trump, right? Kind of important.
No.
Like, that's any kind of
let me finish, and I'll give it back to you guys. But it is ridiculous to say this shouldn't have been brought in New York, and we can address the other issues momentarily.
So the district that it's brought in overwhelmingly votes Democrat, and it's clear. Like, we could talk about jury stuff. I don't think that's the most interesting part. Pisco correctly tells Rashad not a good argument that if the judge is biased, it doesn't matter because the jury has to find, because a judge through jury instructions could swing the outcome, and the jury instructions in this case are very suspect and likely to lead to grounds for appeal in many ways, which hopefully we'll get into. But I want to talk specifically about the political prosecution. Now, I'm not going to bore you with this, but I was thinking about this. It's sort of like when you debate issues on trans, and you'll debate someone and they'll say, like, I think that we should remove the genitals of 10-year-olds. That should be allowed. And you could get into the science with them. You really can. But the real argument is, anyone who's remotely objective could see how stupid this is. It's the same with this. Anyone who's remotely honest could see that the lawfare that's been going against Trump since 2016 is unprecedented. Illegally spied on him, using FICE warrants, him and his team. They've gone after his lawyers, pierced attorney-client privilege, gone after everyone connected to him, dragging him out in the middle of the night while CNN cameras are there, etc. So to make this as simple as possible, though, in one specific way that we'll try to talk, we have to ask ourselves if this would have been brought against anyone else. Would Alvin Bragg, this DA, brought this case against everyone else? Now, Pisco says it's a big deal. It was such a serious crime, overpaying taxes or federal election violations. This is so serious. So my question to Pisco is, why didn't Alvin Bragg in that same election in 2016 decide to subpoena evidence from Hillary Clinton, who the FEC had already said had committed an FEC violation? And real quick, just so the audience understands, Bragg did not know if Trump had committed FEC violations, tax violations, etc., when he started subpoenaing the records going after Trump 6 years after this alleged crime. But he did know that the FEC said that Hillary had violated that. So why didn't he go back and look at her and Hillary for America's business records?
Was he even in power then?
As a matter of fact, I believe Cyrus Vance Jr. was the person who issued the subpoenas. I believe that there was a big Supreme Court decision called Vance v. I forgot actually the name of it, but it might have been Vance versus Trump. So I think that the subpoenas that you're referencing, I think those are third-party subpoenas as well to other entities. Again, just correcting the chronology, I believe there. If you want to compare the Hillary Clinton case, there is absolutely zero comparison in terms of, number one, the body of evidence, linking Hillary Clinton to anything related to
Hillary for America. Hillary for America.
Hillary for America, which is a New York entity, but there's no evidence that these payments, the payment that was labeled as a legal expense to the law firm at the time, part of which went to Fusion GPS. There's no evidence that they structured the payment to hide it as income.
Not true. Yes, they did. There is evidence of that.
To be 1,000% clear, there is no evidence of that. These amounts were disclosed to the FEC, and there's no evidence of any kind of criminal intent for anyone behind this this episode. And
I would like to read. I would like to.
If you don't mind, the comparison
I'll go to actual case law while Pisco is dishonest. So, for example, in the violation, the FEC had quote point 15 during the 2016 election cycle, Hillary for America appointed a $5,600,000 payment to Perkins Coie with the purpose described as legal services. The DNC reported paying Perkins Coie $6 million for the same thing. The DNC violated this law as well. However, the Post reported Perkins Coie itself largely confirmed that Hillary for America and the DNC, quote, shared the cost of paying Fusion GPS through Perkins Coie to conduct opposition research. Therefore, the purpose of at least some of the portion of the payments to Perkins Coie was not for legal services. Instead, those payments were intended to fund opposition research. And so what they did was they structured the payments in a way that didn't look like they were funding opposition research. Now, Pisco told you previously that that sort of falsification of paperwork, it doesn't matter if it materially changed the taxes, for example, this was still considered a FECA violation. And what he's trying to do now is, I'll ask Pisco a question, but I'll finish and then leave him to respond. My question is, was this a FECA violation by Hillary for America? And given that these documents were submitted and by the definition of the jury instructions are business records, if you agree this is a FECA violation, then you agree they falsified records to commit a conspiracy to affect the election, and it was a FECA violation. So was it a FECA violation?
Number one, I do not agree with your premise that the underlying disclosures to the FEC constitute business records over which the New York DA has jurisdiction, as you saw with the underlying tax.
That's not true.
That's
erroneous.
So excuse me. So I thought I was responding, but you can go ahead and talk if you'd like to, or do you want my response?
No, finish Pisco. Hold on, finish Pisco, then we can respond. But then I do want to get other people.
Yes, the definition of business record as defined in the operative statutes, they're broad, and they do convict like any kind of activity that's ongoing. The state of things going on. There's some interesting case law that I'll point you to, but typically the New York state prosecutors don't have jurisdiction over those documents themselves. Although obviously if there's a separate New York business record that isn't the filing itself that you can connect to, again, lacking the criminal intent and noticing the difference between a civil violation under the FEC. The FEC is a civil regulatory agency, and a criminal one, which are very different. I could concede that this is probably, a civil violation that is worth having this settlement over. I do not concede that it's a criminal one. And so, again, there is just zero evidence that make these cases comparable. There's no underlying New York business record that I identified that can tie them separate from the filing itself, which I don't believe the New York DA has jurisdiction over.
Okay, so that first off, notice when it's a novel
theory, and then I want to make sure
when it's a novel theory to go after Trump, it's okay that it's never happened before. That's fine. Then when it comes to this, now keep in mind that you're Bragg or Cy Vance, the person before, and you decide 6 years after the 2016 election to start issuing subpoenas against Trump because allegedly his crimes were so serious in affecting the 2016 election with falsification of records. Now at that point, you don't know if he's committed a FECA violation, you don't know if he's committed tax fraud or any of those sorts of things, but you have suspicion, so you look into it. Meanwhile, the federal entity in charge of FECA, one of the very laws you were saying are necessary for Trump to have committed to commit this 1715-2, you know that they've already said that Hillary committed that, but you choose not to subpoena the records. The other thing is, Pisco is just flat out talking out his ass that somehow they don't have the right to consider business records that were submitted to the Federal Election Commission. That is absurd. The definition of business record, I could read it if you want, but Pisco is well aware that it's talking about any record for the purpose of businesses. Just because you submit, that would be like saying they don't have the right to use as business records federal tax records.
So
that's absurd.
So two things before we interject, two things. Thank you for the gift subs. Thank you for the super chats. I'll read the super chats nearer to the end of the stream, but keep giving them me. I will read them. I just want to make sure that we get through these uninterrupted, and I see the bits and the subs on the Twitch side, so thank you for that. The second question, which I have for Rob, just for my own edification here, so I make sure I understand your argument. You are arguing that Hillary Clinton did a similar thing to Trump And your argument, as I understand it, is that she should be prosecuted for it?
It was Hillary for America, which was a New York entity.
sure,
Fits
sure.
the definition.
That
The
should be
argument is
prosecuted?
the argument is it's proof of selective prosecution. So take these two facts.
So you don't think she should have been prosecuted for it?
He has no evidence whatsoever linking
not
Hillary
true.
Clinton to a violation. That's
let me
what Wick
fin-
just sussed out.
There we go. Okay, so let me answer you, Wick, right? My argument is that no, neither of them should have been prosecuted, particularly by the New York State. I have no problem if the Federal Election Commission wanted to fine Trump like they did Hillary. He should have received the same punishment or a similar punishment. However, the case of Hillary is a stronger
So it was a
case to
campaign
make-
violation. You just admitted.
if they could
You
look,
just
I don't think
admitted
it was. Listen,
You just
let
said
me
you think you
finish.
should be fined.
I said
You
I would
agree
have
it's
no
campaign
problem if it was a fine. It wouldn't have been something that I was screaming about.
Why?
But no, it
Wait a
wasn't.
second. Why would you think it's
No,
okay? if you
we
let
gotta
them
let,
admit it?
hey, we gotta let Rob finish. We gotta let Rob finish.
talk-
Give him the floor.
Hopefully we
and
get
then
to talk. Hopefully we get to talk about federal election violation. I don't think this was. I'm saying I wouldn't have a problem if they gave him $100,000 fine, slap in the wrist. It would have been like whatever. It wouldn't have been a big issue. But no, he did not commit a federal election campaign violation. In fact, it was Hillary because in order, as Brad Smith, the former FEC chairman, will say, and we'll get to, he says that when you look at these statutes of federal election campaign statutes, that it has to be for the exclusive purpose, basically, of the campaign that you had this expenditure. So there, for example, let me give you an example he gives. We'll see what Pisco says. Pisco, if I buy a house so that I could run for office in a jurisdiction, is that a campaign expenditure?
Yeah. So the question is, if it weren't for the election, would you not do it?
Correct.
It's not exclusive. What you said is exclusive.
So
purpose.
if I buy a house, a house to exclusively run in a district, is that a campaign expenditure?
And of course, this only applies to candidates. And there are other rules that exempt certain purchases, and you would have to look into the rules about bona fide purchases for mortgages and for houses. You'd have to look about, to see whether or not you're in a reporting period. It's a little more complicated than you think, Rob. You can't just use your intuition to come up with a hypothetical and thereby assume that the law would apply that way. If you haven't done your homework, then I am not willing at this point.
Hold on. Let's talk about doing the homework.
I'm not willing to do my homework.
Hold on. Let's talk about doing the homework. Let's talk about doing the homework. I want to show how dishonest
I see you,
Pisco's being
Lockhart.
here, right here. Let me
me
just give you an example, right? So he brought up David Peckerhead or whatever his name is, that was the manager of National Enquirer. Let me give you an example of some of his outstanding journalism that he used his checkbook journalism.
Gibbs, you're making their argument.
No, hold on.
You're making their argument. Gibbs, do you understand that? You're making Pisco's argument. You understand that?
Can I finish? You don't even know what my argument is.
I do.
You might think so. So, listen, this guy said here, he's published things like Gordon Ramsay, sex dwarf eaten by badger. Osama bin Laden has a weather machine. All sorts of wild stuff. This is clearly not a credible witness, right? Michael Cohen, his publisher, not a credible witness. And he has the audacity to sit here and say with a straight face, oh, well, you don't know what you're talking about. Let me just use this guy as my shining example of a witness that can link Trump to these crimes under the tabloid thing.
Hold on, isn't that the guy that Michael Cohen mentioned in that recorded phone call? So we know, based on the recording, that David Pecker is the homeboy of Trump and Michael Cohen.
Oh, no.
But here's the thing.
So isn't he reliable?
Hold on, just let me finish here. I'm almost done. Michael Cohen, once again, is a convicted perjurer. That's what he went to jail for.
He perjured himself, and he lied trying to protect Donald.
What did he lie about?
He lied trying to protect Donnie, though.
Let me finish. Not only you can argue that may or may not be true. It's no relevance on what I'm about to say. The fact that their whole career has been built on the outstanding values of their journalism, like the things I presented, shows that they're not credible witnesses. You can't take them serious. And if this is the only link the Dems have, Pisco here might as well change his name to Pisco because he's taking the truth and pissing on it. It's terrible.
Could you tell me more about how convicted felons can't be taken seriously?
No, and this,
Can
I follow up with something that Rob said?
Not a kangaroo court.
Well, I think something Rob said I think was really important when you're saying buying a house, because this literally happened, right? In 1999, following Hillary's announcement that she was running, by the way, she was already a candidate at this point, the early 1999. And then in late 1999, September, her and Bill bought a house specifically for the purposes of her running for New York. Now, under the logic of, if you spend money for a campaign purpose, therefore it's you not only can use campaign funds, but you're obligated to use campaign funds. I think not only demonstrates probably a double standard here. Hold on. Probably not only demonstrates double standards here, but I also think it speaks to like the ridiculousness of this, which is that obviously it's not a campaign expense and they should have not been allowed to spend campaign funds on it. Because under FICA, it's a mixed use, right? Now, I would argue
you have to use campaign funds. That's the weirdest thing I've ever heard.
You'd be allowed to.
Hang on. My question is,
hold on.
Where does it say that Donald Trump had to use campaign funds?
He would be.
Let me finish real quick, because what you're saying is if they bought it, that would be required to be recorded as a campaign donation.
Wait.
Right?
I'm sorry.
So that would be.
I'm going to ask my question.
Hold on. I'm in the middle.
Yeah.
So it would be a campaign expense, right? Or really a contribution, because it would have to come from the Clintons.
Now they're going to buy it anyway, right?
Well, no, they weren't. Hold on. Thank you. Yes, they specifically were not going to buy it otherwise, because they bought it in September of 1999 when she had already begun to run for that area early, I think in January, or at least early in 1999, regardless. And so the reason why it's obviously not campaign funds is because under FICA designations, it's obviously mixed purpose. I think the payoffs to Stormy Daniels, in my opinion, is not a campaign expense, given that they were already trying through various means to get Stormy Daniels to not talk about this as early as 2011. So there's other purposes that a married man might want to, and sure, election might be part of it, just like Hillary Clinton wanted to move there for the purposes of running, but that doesn't make it a campaign expense, obviously.
Question to you, Lactoid, if I may then. If this was, again, not, or is your argument, as I understand, and correct me if I'm wrong, is that this didn't constitute a campaign contribution or a campaign payment? Yes, no. That's your argument?
No, yeah, it's my argument. It's a personal house. Yeah.
But if there is evidence in the trial, as Pisco mentioned earlier, of them structuring it in a way to look like a campaign payment, is that a problem for you?
No, they didn't.
That's not what happened here.
The opposite of what happened.
Not even Pisco would say this happened here.
Maybe, like I said, maybe I misunderstood.
And there's other points to make on this. For example, the payments weren't made until after the election anyways, right? So the idea that they were falsified to affect the outcome of the election exclusively in its campaign expenditure is nonsense. Now, Gibbs, I love you, man, but you stepped on my toes there, because I was going to bring up exactly what Lactoid did, that this isn't a hypothetical that's actually occurred with Hillary Clinton and many other politicians. In fact, under the theory that Pisco's using, if you had to say anything that's possible to be used for a campaign expenditure would be something you have to put as a campaign expenditure, so anything that could benefit the campaign. For example,
your water bill, your shower.
So this is a real situation. I ran for Congress, and in my running for Congress, it turns out that a house that I sold to someone, they never went to the magistrate and put it in their name. So when they did a background check on me when I was running for office, it turned out that I owed back taxes. I said, what? Now, one, I paid those back taxes for the express purpose of the campaign. That's the only reason I did it, right? Because they weren't mine. Or I'm sorry, I didn't. I was going to pay the taxes. What I ended up doing, though, was I had to go to a magistrate again. I had to convict this, or I had to get this person to lose a judgment against me. Then I had to pay $200 to evict them after 30 days. And all of this was to clear my name for the campaign. According to Pisco's theory, one, I committed a campaign finance violation because I did not put that down as a campaign expenditure. And second, if it is a campaign expenditure, that means not that I have to use campaign funds. I could pay for it myself, but I'm allowed to use campaign funds. That means under Pisco's theory, Trump would have been allowed to use campaign funds that like normal Americans were donating to him to pay this NDA. Hillary would have been allowed to use campaign funds in order to purchase this house. And the way that Pisco gets out of this obvious double standard is just say this. No, it's more complicated than that. I'm sure there's other laws. Pisco, can you cite me the law that says, oh, and when it comes to federal election campaign laws, purchasing a house doesn't count? Can you show me that law?
Yeah, so as I sit here now, I cannot produce you all the exemptions for expenditures and contributions, but I promise you I will look into the issue of the house hypothetical and get back to you. But again, if the house was going to be purchased no matter what, and you've represented that it hasn't been, but again, people make mortgage decisions. You know, who knows when and why they made the decision and what the evidence was at the time that purchase was made. But you made a misrepresentation before, which was that they had to use campaign funds to pay off Stormy Daniels. Why did you say that, and why is that relevant to what you're talking about?
No, what I'm saying is that it would become campaign funds since you have recorded as a campaign contribution, right? That would be the argument. Hold on real quick, Pisco. Your argument is that this needed to be recorded as a campaign expense, essentially from a contribution from yourself. That he should have recorded that as a campaign expense.
We're talking about illegal. We're talking about illegal campaign contributions, right? The expense aspect to it. If an expense is,
I'm going to mute here real quick because I'm curious. Do you guys know why my computer screen like glitches constantly? Like, is there a driver issue that would cause that? That would cause my Elgato monitor / teleprompter to like glitch out, and then it throws the screen over here, and then it resets. It's done it multiple times. Do you guys have any idea?
civil penalty that Trump would pay. And so,
do you understand what I'm saying, though?
But hang on a second. You just said that, and so why would you be okay with that if he wasn't a campaign contribution?
I would be okay with the fact that I do not think, and I've spoken vociferously about this, I don't think it was a campaign contribution. I would be okay in the sense I'd say, who gives a fuck? They fined a billionaire $100,000. It doesn't matter to me, right? But it is not a campaign.
All right, because I'm boomer. What would if it's a graphics card drivers, because I have Intel, do I need to go to like Intel's website and update the drivers? I'm using Microsoft Edge, by the way. It's also screwed me up like in my recorded videos throughout the day where it glitches out and I have to basically start with the recording over.
Clinton. But when it comes to an NDA of Trump, oh no, a billionaire could only ever want an NDA of a woman who's extorting him only if he's running for
There was no
office.
extortion. Hang on.
Please,
there was no extortion.
Especially since it was 2011 has when they were trying to shut her up, essentially.
That's
well before he was a candidate.
So
Yeah, I mean,
a
because
couple
sex workers have never been
misrepresentations.
known to blackmail clients. forever.
Hold on. Around that time, she was
misrepresentations.
actually working with Cohen to shut down the spreading of the story without her permission.
No. Cohen was basically getting her to stop spreading the story. They weren't working together.
Her lawyer in consultation with Cohen, right?
Yeah, because he threatened to sue her. That's why he threatened to sue her multiple times if she published the story back as early as 2011.
Right.
So I think if we're going to be charitable and say, well, people buy houses for other purposes too, which is true, which is what FICA's position is. You also should be equally charitable and say, well, people might buy an NDA for if you're a billionaire for other reasons too, especially if this was happening before you were candidate back in 2011.
So if you believe for a second that this was not about the campaign and this payment would have been made, absent the campaign, I think you are being taken for a ride. We have evidence from the direct testimony of these individuals involved in a scheme that they had silenced other people before. There were 2 other stories using the same scheme for the same purpose that all date back to a meeting in Trump Tower in 2015, where David Pecker said for the purpose of the campaign, and Hope Hicks confirmed these payments were made. And that's why the Karen McDougal story is relevant. They show a common scheme, and this scheme involved silencing women for the purpose of helping the campaign. If you listen to the testimony about where the Trump campaign was at that time, when this payment was made to Stormy Daniels, they were in pure damage control. I remember when the Access Hollywood tape came out, I remember talking to my buddies and say, all right, it's all over for Trump now, after hearing that. This was an absolute crisis moment. Hope Hicks describes it vividly. And up until that time, Trump was not paying. And there was many times where the deadline to pay Keith Davidson, who was representing Stormy Daniels, had passed, and they had withdrawn the offer. And not until the Access Hollywood tape came out and his campaign started being attacked and he felt the pressure did he come out and make the actual deal. And then, of course, days before the election, when the Karen McDougal story leaked, he was also irate and angry about it days before the election, not because he was worried about Melania Trump, who was also involved in some of these, at least the coordinating of some of these calls, but he was worried about the effect on the campaign.
Hold on.
I have to ask Pisco. I want to ask Pisco one question.
I want to question Pisco first.
Yeah, hit me.
Because I'm curious, right? So as you've described it, they did this in order to hide information that was.
You say did this? What do you mean? Did this?
Like the payments,
NDA, paying
right?
Stormy.
NDA, etc.
Yeah,
why
they
is
paid
that
it for the campaign, yeah.
illegal?
The
again?
NDA is not illegal. Like a contract is not illegal.
Sure.
So
why? What's
So
the?
she would have you would keep a copy of an
Hold on,
NDA,
stop,
right?
Gibbs, please. My question is, what is the underlying illegality of what was being done?
Yeah, the illegality was an illegal campaign contribution by Michael Cohen to Donald Trump in the form of a loan. That loan was the payment by Michael Cohen to Stormy Daniels' lawyer for the purpose of helping the campaign and with the expectation of reimbursement. And
okay,
that is a campaign violation.
I would like to, jump
also,
in because I know. Okay, we got it. We got what that.
What do you mean we got? Wait. There are other laws implicated as well.
Leave Pisco talk for 15 minutes because Wick didn't understand the case. That's what's going on.
The other underlying illegality was the desire to create false tax records. And then what I think is probably the weakest theory, but it's not a circular theory, is that Trump intended to facilitate the false business records related to, Michael Cohen's organization of corporations and stuff like that.
That's a reversible error, Pisco, by the way.
I don't think it is.
I want to touch on that. I think that's going to be the reversible error.
So I would like to finish up this point, if I may. So the point is this. In 2 instances, we've showed with just Hillary Clinton, and the truth would be that this would be many other people. And it is an apples-to-apples comparison in this part. You could say Hillary was so long ago. Right, so were these charges from 2016. Literally the same election, what's going on. So
what's the business record for the House payment?
Please.
Wait. What's the business record in the enterprise?
I'm going to let you interrupt me. You just talked for a considerable
Yeah, what's the business
time.
record?
So the business record is business record definitions are any records of a business that's submitted
for an
to
enterprise. What's the enterprise for Bill and Clinton?
Hillary
for that
for
house?
America?
Wait, no, for that house. Wait, that's
this is Weasley.
Hey, hang on a second. Wait a second, Rob. That's 1999, right?
Please.
That's 1999.
Please,
not Hillary for America,
to finish
right?
my point. I'm going to finish my point.
Okay.
So what I was talking about specifically here, and then we'll get to the House portion. What I was talking about specifically here was Hillary for America was the business entity in New York that had business records, the improper filings to the FCC, which the FCC said violated the law. And when you bring this up, like, okay, that's clear cut. Why weren't there even subpoenas on their records? Why wasn't their charges brought up? Pisco's just like, trust me, it's different. Trust me, I personally don't think it was a violation. Where it's more clear cut, because we're talking right now, Lactoid, me, and Pisco are talking about, can you have NDAs for the purpose outside the election? There is zero chance that you get opposition research, but for the purpose of an election. So both in the fact that a federal agency had already ruled, please shut up, Pisco. A federal agency already ruled that this was a violation of the law, and it is way more clear cut when it comes to the Trump case that this was actually a campaign expenditure.
Yeah, but they reported
it's clear they did not report it. They falsified the records. They falsified the records. They were reported, but they were falsified as the FEC ruled. So Pisco can say
there was no final rule.
If you don't shut him up, I'm just going to head out. I thought I was pretty polite. He's interrupted. I've interrupted a little, but
shut up. You both interrupted each other fucking a lot. You can both get your time. I'll make sure you do. But if you're going to interrupt him, he's going to interrupt you. And I'm going to let it slide because, again, content. But the floor is yours now. Continue. But please, careful. Go ahead.
Now, don't tell me careful, right? He started with the interrupting. I admit everyone does it once in a while, but he just had a large chunk to talk. So I'd like an opportunity without him every 3 seconds to be interrupting. I think that seems reasonable. If you're incapable of handling it as moderator, that's fine.
Please, you have talked more to... if you had used the energy that you attack my moderation to make your point, maybe you'd be doing better right now. But you're not. So fucking finish. Go.
Anyways, Wick, what we see is that when it comes to the campaign finance violation, it was a clear-cut example. He doesn't have an argument. He just says, no, I don't feel that's the way. They didn't even investigate her. They could have found more evidence if they'd looked at Hillary for America as to whether or not what she ordered, but they didn't do it. And it's constantly this way. They constantly choose not to look into things when it comes to the opponents of Donald Trump. They chose not to give a bunch of people, when it came to the classified documents case of Hillary, they chose to give everyone immunity. With Trump's team, they choose to charge everyone, to go after as hard as possible. It's the same here with Bragg. It's clear as day. The other thing when it comes to the question of the House, we could see when it came to this payment of the House, it would be a campaign expenditure to be able to buy this house. So for example, if she got any sorts of loans like mortgages and didn't pay out of house, that would have been a loan that was given to her for the purpose of purchase or for a campaign purpose. And the only argument that Pisco has is, no, trust me, there's exemptions. Well, you could choose to take Pisco's word, or you could choose to take the former FEC commissioner's word, Brad Smith, who actually was tasked for years with charging these sorts of violations, who wanted to testify in this trial, who says absolutely not. This was not an FEC violation, an election campaign violation, because these sorts of things wouldn't constitute. He specifically brings up the example of Hillary's house. And he says, by the book, if you read the statute as written, you would say, oh, well, this was for the purposes of the campaign. And therefore, if they didn't file file it as a campaign expenditure, then that's misreporting of the campaign, which would mean that they at least violated campaign laws. We could talk about the falsification records earlier. The reason this matters is as follows. Because this would be tantamount to saying anything that could affect an election whatsoever would be a campaign finance expenditure. This means if it's a campaign finance expenditure, you're allowed to use campaign funds. That means, in effect, what Pisco is saying is, absolutely, that Clintons would be allowed to get a bunch of donations and purchase a house if it helped her win the election. And the other thing that's ridiculous about this is you can see how charitable it is when it comes to everyone other than Donald Trump. When it comes to Donald Trump, it doesn't matter that he was trying to shut this story up in 2011. Doesn't matter. It doesn't matter that we can see that the billionaire would have purpose to have other NDAs. And so you can see the double standard that's being employed here. Another question I have for anyone on the left, with the slush fund, the congressional slush fund that paid off women, if those payments occurred during a campaign, are those campaign expenditures?
Good question, Rob. What a great question. You understand there's an exemption for the federal government?
I do want to make sure other
Would
people
it be a
get
campaign
into,
expenditure?
right?
Hang on a second. Do you understand that the
but I want to make sure
definition?
that Lactoid.
Yeah, I know, but
Stop. I'll let you respond, please. My God. But I will let you respond, but I want to make sure to open it up again because we talk about everyone getting equal time. Like, oh my God, you guys have really gotten a lot of time here. And I want to make sure that Josiah, Gibbs, Rashad, Lactoid all get time, but respond and then we can go. Go ahead. Please go, it's yours.
Sorry. Yeah, so you understand that the federal government is not a person under Federal Election Campaign Act statute. Is that right, Rob?
Well, that could be true, but that wouldn't mean that it's not a campaign expenditure. You could just say they're exempt from...
Well, who gets to make campaign expenditures under the law, Rob? Is it persons?
Persons and corporations, like groups.
Is the federal government a person under federal election campaign law?
No. But let me ask you this. Are there...
Whoa. Let's just stop in that moment for a second, right? That is an interesting point to bring up because there's an exemption that could potentially apply. And you ridiculed me earlier by saying, oh, exemption. There's a lot of exemptions here that I will look into the particular case of the House. I wasn't aware about it before. And now that I know it, I will look into that matter. And maybe there is a double standard if I look into it and see that something's wrong. I'm not going to take the word of some FEC stooge that Trump appointed and who wanted to testify for Trump. I'm not going to take the word of you right now sitting here. And no matter what, you're not going to argue to me that Bill and Hillary Clinton as a marital household constitutes an enterprise such that they would be liable to the false business records statutes. And so with respect, at least to the DA, I hope that you would agree that that payment to for the house or mortgage or whatever that it was, that there's no sign of double standard with respect to the DA. Is that right, Rob and Lactoid?
Yeah, I'll answer with even beyond that, the statute of limitations long beyond that anyway. So no, I'm not saying that Bragg or Cy Vance would had to look back at that.
No.
Please,
that's not my question.
Please, your question is it a double standard that Cy Vance and Alvin Bragg
no,
didn't
that's
go
not my
back
question.
and prosecute?
That's not my question. So
well,
you agree?
I'll continue to answer. I'm sorry that you were unclear in the manner of question. That is your question. Let me ask you right now. I'm going to leave you. I'll leave you re-answer, but just to see if you're good faith. So the end of your question, what you're going to say is, no, I'm asking if the reason it's not a double standard that you didn't prosecute him for this specific reason. But what I just said was fundamentally true. Are you saying, Rob, that it's not a double standard that they didn't look into this?
No,
okay, go ahead then.
That's not what I'm saying. I asked you whether Bill and Hillary constituted an enterprise such that they're not liable under the business records for this payment so that there could be no double standard alleged with respect to the DA, not any particular DA, but the DA generally. So forget about the statute of limitations. Because Bill and Hillary Clinton are not an enterprise under the law, the business records statutes wouldn't apply to them, right?
We got it. Right.
Do you agree with that?
So when you said the DA, you meant any DA. That's what you meant.
The New York DA.
That's what you meant. Any DA. Gotcha. Yeah. Right. It doesn't matter. Like it wouldn't be a double standard anyway. It wouldn't be a double standard anyways because it was far beyond the statute of limitations. As to the question of the falsification record, I would have to look into the specifics of these. When it comes specifically, again, just real quick, we have two examples that this would still be a federal election campaign violation, which we are talking about, which you don't need to be a business entity. And that's why we're talking about the House specifically. So what Pisco does is he moves the goalpost. When we're talking about was this a federal election campaign violation, he says, but it's not falsification of business records. Right. No one said that. We're talking about specifically if this was a federal election campaign. When it comes to Hillary for America actually being fined by the FEC for violating federal election campaign laws, Pisco's argument is, I don't think so. I think they were wrong. That's his argument. And so therefore it's not a double standard, which is bullshit. I'm sorry. I don't take someone who's a hyper partisan like Pisco's word over the FEC that said that this was a violation.
Yeah, okay, I got a question.
No, everyone stop. I want to be the other people, and other people have to talk here, right? It's not just the Pisco Rob show. Rashad had a question, then I know Lactoid wanted to go, and I want to make sure Gibbs and Josiah get speaking time. So Rashad,
okay, just a
Lactoid, then yeah.
Just a question. So if Hillary and them were fined for this, wouldn't that mean that they were held accountable? Because I feel like the argument
Hillary
here is
wasn't
that
fine, right? Like this is all a misrepresentation, and he even pretending that there's some like finding of guilt. What happened was a settlement. They didn't want to litigate it anymore, and so there is no like finding of guilt from a court or anything like that. This wasn't a criminal matter, as I said before. The FEC is a civil regulatory agency, and the standards for finding a criminal violation of Federal Election Campaign Act violations is very different than the standard for a criminal, obviously. And
you know the facts.
Lactoid will admit to that and say so. And there's nothing tying Hillary Clinton to what's going on there. It's a total red herring. And also the payment was reported. And again, you cannot say the same thing about the payments with respect to Trump.
The payments were falsified.
Okay, so a couple things. I wanted, the reason that we're bringing up the House specifically is that if that was purchased for the purposes of an election, the question is not, again, I think Rob said, we're not talking about falsification of business records necessarily there. We're talking about whether or not this should have been logged as a campaign contribution. Now, my question for you, Pisco, is you said before, well, they could have bought a house for another purpose, which I agree with. What was, if you're saying that the payment to Stormy Daniels was specifically for the campaign, what was the motivation for Donald Trump paying Michael Cohen to go after Stormy Daniels in 2011? What specifically was that motivation if you're saying that the payment was only for the campaign? Was not an excuse.
So threatening to sue and sending a cease and desist letter for a story that's been admitted by Stormy Daniels, and I think maybe even contemporaneously had many errors in it and was up for like 24 hours. That is very different than being willing to you yourself make a payment. So you see the different postures there. One is a posture of admittedly false story and coming and sort of going after them and with a cease and desist. And you're asking what the motivation is. You know, there could definitely have been a reputational thing at stake there for sure. And no one's denying that there could be a background reputational thing. There are mixed motives all the time. The question is, would this payment have been made but for the campaign? Would they have paid but for the campaign? And the answer is
hold on.
no.
No, I disagree with that, right? Because again, despite the fact the house purchase was done for the purposes of living in New York to run, like you can still theoretically, like we can think about, okay, why there's plenty of reasons why you might there's plenty of reasons why you might want to buy a house too, to live in it, right? But in this case, we don't have to speculate. We have Donald Trump paying Michael Cohen, because I'm assuming Michael Cohen didn't work for free here, that they paid Michael Cohen to go after Stormy Daniels as early as 2011. So he's paying money to try to silence Stormy Daniels as early as 2011. And you're saying,
first of all, you don't know that. Because a lot of times Cohen was not paid for legal services, but you can go ahead.
Well, sure.
Just let him finish, please.
So I guess the assumption is that he paid Michael Cohen for his legal services, for working for him. Regardless, at the behest of Donald Trump, Michael Cohen was doing this, right? Was going after Stormy Daniels to try to shut her up as early as 2011. You're saying that's because of some kind of reputation interest, which I would agree with. I think there's
a false story as well.
There's absolutely a reputation interest in silencing Stormy Daniels. There's multiple instances in 2011 in which Michael Cohen was silencing Stormy Daniels. And so do these reputational interests just disappear once you get closer to the election? Absolutely not. Like, sure, there is this new motivation of wanting to look good.
Let him finish.
There's this new motivation that comes like when you're beginning to run for something, but there's obviously a mixed motivation here because there is this other motivation. If you're going to hold this standard, which is even a mixed motivation, if done for the purposes of campaign, needs to be reported as a campaign contribution, you get into just like wacko land.
You're
where,
misunderstanding.
well, hold on, no, I'm not misunderstanding, because then you would have to log your water bill, because showering looks good for the campaign, so you got to log your water bill as a campaign contribution. If you buy shampoo,
You're
you have to do that.
So
what specifically am I misunderstanding?
So mixed motive is not what's bad here, right? It's not like saying, okay, this is good for this, but also for that. The question is the campaign a but for? That's the question. And there are, again, other exemptions relative here that might deal with certain kind of like, you know, if you're showering, if you purchase something for your hair, there are these kind of bona fide exceptions that exist in the law so that you don't get into this ridiculous territory. So just to be 1,000% clear, it's not, did you have any motivation for the campaign? It's, but for the campaign, does this contribution happen? So with this particular payment, and the reason why it's in 2011, think about the posture here. In 2011, it's take that down or we'll sue you. And now in 2016, it's, we'll give you all this money to shut up.
Well,
because that is a materially different.
Well, I understand, because this is like it's ramping up, and obviously this isn't helping, right? Or this isn't stopping her, and so you get into this.
There's a reason that posture is different, Lactoid. There's a reason. It's the campaign.
So
let him answer, please.
Yeah, this is important, right? So the prior instances of attempting to shut her up that were unsuccessful absolutely can lead to an NDA at the end point. You and I both know this. There's plenty of cases that you might not settle right away, but then as you go on, as you get closer to trial, then you might settle it. Then you might pay more than you were initially willing to pay because of, well, shit, we're getting close to trial. Like, it's been going on a long time and they're not giving up. And the facts are actually kind of worse for us. And the things that we thought that we could do here and the testimony that we thought that we were going to get, it's simply not coming to fruition. There's that motivation. Is it absolutely true that when you're running for office, are you going to not want to look bad? For sure. I'm not saying that's like not a potential motivation. But when you're saying but for, beyond a reasonable doubt, by the way, Pisco, hold on. No. The jury needs to be, like, you got to prove to the jury here that but for the election, beyond a reasonable doubt, when this evidence exists from 2011, that he could not have made this NDA payment without the campaign. That the evidence isn't there.
Okay.
So you think
quickly, concisely, that Gibbs is going to die.
It's just a coincidence that this, the sex happened in 2006. And 10 years later,
that's your argument with the House.
The deal was coming to a fruition anyway. But we have more evidence here with the campaign contribution. You have Hope Hicks' testimony under oath. Who knows better than the insiders who are part of Trump's campaign? Put aside Michael Cohen.
What did she say? Did you read that transcript of all that?
Yes, I did. David, I read that testimony. David Pecker is saying that this was part of an organized scheme to catch and kill. That's David Pecker. They had done it in the last year with 2 other stories, all funneled through AMI and the National Enquirer.
He also told Dylan Howard that we are going to try to help the campaign, and to do that, I'm going to keep this whole thing that we got going on as quiet as possible. So the witness testimony corroborates.
Yeah, hold on. Catch and kill's been going on since 2011. Here's my ultimate point. You're saying,
when was the campaign?
Donald Trump's campaign, that was in 2015
and 16.
Okay, so and 16, not 2011.
But David Pecker says, who's a part of this scheme of catch and kill, in 2016, he says, we are going to try to help the campaign. He is a part of this scheme.
No, wait.
To the crime.
I'm the one alleging mixed motive here. I'm saying that for sure, when you're going to run for something, just like in the case of Hillary Clinton, when you said, I think it was your word specifically, Pisco, well, there's other reasons why you might want to buy a house in New York. You said that. Hold on. I agree with that. There are other reasons.
Or cause.
Yeah. So
it clearly
when you have Hillary Clinton, who specifically buys a house in New York because she's not eligible to run there, but the campaign had already started earlier that year, I think that's more reasonable to believe it's a but-for payment than opposed to this when you have litigation occurring as early as 2011, when Michael Cohen's tracking down Stormy Daniels, threatening her with lawsuits and threatening the publishers of her story with lawsuits to shut the fuck up. I mean, this has clearly been going on since 2011.
The only point made around that time.
Wait, to test your consistency, what you're saying is it's beyond a reasonable doubt that Hillary Clinton bought that house for the campaign, right? At that time.
No. I'm saying it's closer.
Are you saying it's beyond a reasonable doubt?
Hold on. I'm not saying that. I'm saying it's closer. It's closer to beyond a reasonable doubt that she bought that house solely for the campaign and it should have been a campaign contribution than it is that Trump paid off Stormy Daniels solely for the campaign.
But here we have insiders who are saying specifically that was the
Insiders.
purpose. We have people in Trump's payroll saying that. Put aside
Yeah,
Michael Cohen.
What
We
the testimony of
don't
Weisselberg
have
said.
that.
Well,
Weisselberg wasn't called in. This is a red herring. I don't know why you're trying.
Well,
this.
I want to see where Rob goes with it. Rob,
he
please.
knows it was. He's trying to do a little routine where he thinks that I'm going to say I don't know it because I didn't know he was called. Yeah, that's exactly what you're doing. It's pathetic. It's pathetic.
Like, again, I understand. Like when you're, so two things here. One, we can see that Pisco is willing to be exceedingly charitable. Her literally starting the campaign and then basically knowing, oh shit, I can't run here unless I have a property. Now I'll buy a property. He says, no, I could think of other reasons. But with Trump and the NDA, who was trying to silence this in 2011, he says beyond a reasonable doubt. I'll go further than that.
Easy.
I will say easily, I think it's beyond a reasonable doubt what Hillary Clinton did, that she bought that.
So
However,
you agree, Trump.
However, listen, Pisco, I don't think that's a campaign violation because I don't think those sorts of things would be things that would be reported because the logical,
that's my point.
If you would listen to me, I would tell you why. Because if you inverse that, if it's a campaign expenditure, that would intuit that you could use campaign funds for it, which means that you could then, I could literally purchase a house to like next week in California because I could announce right now I'm running for office in California. Then I could take those donations and purchase a house. That's what you're saying.
Wait, Robert, is it your position that buying a house in the way Hillary Clinton did, do you believe that to be a campaign expenditure or not?
No.
So you agree with me that that probably wasn't a campaign expenditure?
No, I agree. See,
I've got to pee. I'll be right back.
Come on. This is what he's doing. So let me show you what Pisco's doing. What he's doing is this.
But hold on, just real quick, Rob, you can. But after that, Gibbs is gonna die. So right after Rob goes, we're gonna let Gibbs go. Rob, go.
I'm saying that I don't think these sorts of things that you could intuit like, oh, well, then you could use campaign funds for this should be things that qualify as campaign expenditures. So when I say that I think certainly she bought that with the intent 100% beyond a reasonable doubt to run in the campaign. It was for the purpose of the campaign, but she still shouldn't be charged. The same argument I'm making with Trump. Pisco's the one who's being disingenuous. He says with Trump, it's beyond a reasonable doubt, absolutely. But with Hillary, who it's clear, can you give me any possible motivation? You're going to tell us with a straight face that Hillary Clinton starts campaigning in New York and then realizes she has to have a property there. So she then, after starting the campaign, buys the house in New York. Why that would...
Hang on, it could have been the other way around, as you think. What you're saying is it's obvious that she bought the house to run in New York, but it could be that she's planning to run in New York because they wanted to live in New York. That doesn't matter. The purchase of the house is the point. That's the reasonable doubt. Wait, hang on. That's the reasonable doubt standard, beyond a reasonable doubt standard. In the Trump case, there's way more evidence of Trump's intent. 100%. Yes, it's not even.
Unlike that, we don't have evidence that Hillary was shopping for a house in New York. It's 6 years prior. With Trump, we have evidence that he was attempting to get this story silenced 5 years prior to when he made these payments. So anyone who's being reasonable, I think that me and Lactoid have a reasonable position where we say both of us are saying, yeah, there's certainly motivation for the campaign for both. It seems worse for Hillary, but we wouldn't charge either of them. That's our argument. Your argument is, and it's like this with every single issue, no. It's only what Trump did exclusively. You're making literally the exact same argument with the FEC violations, which I'd be more than happy to go through Hillary of America and the disingenuous falsified documents she sent to the FEC. If you'd like, we could talk specifics.
Why don't we talk about first? Let's deal with the house.
No, hold on. No, we're going to circle the drain, and then we're never going to get off of this, and we do need to get to other people. I swear to God. Just for the record, Trump was considering running for president in 2012. So simply it being in 2011.
No. Hold on. This is hold on.
Doesn't really do it.
No. Trump. Hold on. Trump said he was not going to run in May of 2011, and then in October of 2011 was when Michael Cohen was hunting down.
Sure,
the
but
stories.
Trump says a lot of shit, so you know.
But he was not running, and he said he was not going to run.
But the
when Michael Cohen was hunting down these stories.
Okay, but Gibbs, please.
Yeah, so I have a couple questions on one maybe somebody can answer. I mean, I'm not going to talk about what y'all been talking about, but I do want to talk about some of the witnesses here again real quick. Let's talk about Stormy Daniels, right? She just had her fraud case dismissed, where she ended up having to pay Trump because they found it, lacking. The whole case that was basically where they presented this NDA that Trump never signed. And so they presented this. Her lawyer was Michael Avante, a known scam artist who just sat here and made some bullshit up, then got arrested and tried, is in jail to this day for things related to that trial. That's the start of this, right? This is where, and so it behooves you to think, hey, maybe is it possible that a scam artist and a hooker got together
Kevin, at
and
least
said, hey,
unless
you know
I'm
what we're gonna do? We know Trump's running for
misunderstanding,
president.
they're referring
Let's
to
go
when
and
Bill and
blackmail
Hillary
them and
purchased
have a
property in New
bullshit
York
thing to put
State
out in the public.
in
And since people hate
1999
him,
when she
we're
was
just gonna run
running
with it.
for
Oh, and
Senate,
then when it goes to a
not in
civil trial,
2016, I
the
think.
burden of proof is lower in a civil trial, and they still dismissed it. And so then when we come to the criminal court case now, that's the evidence you're going to use and say, hey, we have this NDA of the hush money that only Stormy Daniels signed. Her lawyer who presented it is a convicted con artist. And the only people that can connect it to it is a perjurer from the National Enquirer and his El Jefe buddy over there at the National Enquirer who published things like.
Yeah, see, this is I told Pisco this, I told Wick this. You know, this is where I think like it's so good to have attorneys on here because Pisco and Lactoid did the vast majority of this, and they should have because they're the only ones with relevant experience and authority on it. Rob fixates on the story, so he's more conversant in the details. But at the end of the day, I really wish this could have been a Pisco Lactoid conversation. 1v1 would have been more productive.
Trump
I have new evidence.
Denied even meeting her multiple times. It's he said, she said, and they went and took the little tattletales and turned it into a politically motivated trial to try to stop him from being elected president because they have a dimension for the
person who's alleged to have made the payment, facilitated the payments, testified. Hope Hicks also basically snitched and cried on the stand after snitching. And then on top of that, Karen McDougal is another person who had a payment made to her around the time of the election as well. So it's not even like it's just a
I have
other payments that were made at the time.
Chronology.
We're
just gonna let him say. We're just gonna let him say everything he just said.
Hold on. We're not. Everyone's gonna get a chance to respond, but you can't all respond at once because no one can hear what you're saying. So I'm gonna let everyone here respond. This is the order we're gonna go in. We're gonna go Lactoid. We're gonna go Pisco. We're gonna go Rashad. I don't know if Rob wanted in this or not.
Sure.
Sure. And then we'll get Rob. But then I have one more question before we close to the end, right? But it's gonna be a while. So we're gonna start with that. So that's the order. Lactoid, Pisco, Rashad.
I only want to say one thing. I found some evidence. I found a New York Times article from 1999, and the Clinton campaign specifically said that she was moving to New York because she has to live there to run for Senate.
Yeah,
it was not that they were going to live there anyway. That's not true.
Just to be clear, I will look into the 1999 purchase of the home and come back on what my thoughts are about whether or not it proves a double standard. I think that that's fair for me to look at all the facts and to look at the law. And if there is no exception or if there is a business record at issue, I'll come forth and say to Rob, they are an enterprise. Actually, I was wrong. The marital couple can be an enterprise. There is a business record, or even under the underlying. Hang on, I'm going to address everything. So don't worry about it.
You bring up a point no one's arguing.
I'm being comprehensive. So
no,
wait, wait, hey, hang on. So Rob, you are not arguing that the DA should have charged Hillary Clinton. That's right? Okay.
Not in the House case. In the other case, yes.
Okay. So just to be 100% clear, that does not
a federal election violation based on your interpretation.
Okay. And Trump was not charged federally for a federal election crime. Is
That's
that right?
correct. The feds didn't think he committed that crime.
Did the feds treat Hillary Clinton and Donald Trump equally with campaign finance?
The argument is as follows.
Yes or no? Can you give me a yes or no?
No.
Wait, so Hillary Clinton, who was fined, was treated better?
No. Then it wouldn't be equal if they were treated differently, right?
But I'm
just asking. No. Rob, let me ask you direct. So you said no, they're not being treated equal, correct? Can you elaborate on that?
They both weren't charged.
Hold on, I want to let Rob elaborate on it, please.
No, one got fined, the other wasn't. What we're talking about specifically here, though, is states being able to basically charge through other means federal election violations, which is absurd in its face. So what happens is, even if the feds treated both, not really equally, but treated both with some sort of fairness, the state is alleging that there was a federal crime that was committed that they're using as the underpinning and the unlawful means for the state or for the crime that they have jurisdiction over.
But you just said the New York couldn't charge her.
What's that?
I thought you just said that you're
The
not
statute
alleging.
we're
Wait,
doing-
wait. You asked me for
Go ahead.
clarification. I'm giving you clarification. You just conceded that more or less, they find Hillary, but more or less the feds treated them similarly with respect to Hillary Clinton and Donald Trump. So in terms of the DOJ, you're saying there is fairness and parity. With respect to the Manhattan DA, you're saying there's not parity. But again, what you just admitted, I thought you said that you don't know at this moment whether or not there would have been a chargeable offense by the DA in 1999.
The question is, it's not a matter of if it would be a chargeable offense. We're talking about what constitutes federal election violations. And we're saying that if we're saying what Trump did would have constituted a federal election violation, regardless of this law in New York, the falsifying business record, regardless of 1715-2, right, the conspiracy to affect election, just the idea, because you have to prove the unlawful means as well to be able to charge Trump for this stuff. And
Sure.
so if we're saying one of the unlawful means is this federal election violation, then we're saying, okay, but this seems to open us up to a lot of problems, because this would mean that we could look at all sorts of situations. And by the way, we're just using Hillary as an example. This literally happens all the time, right? Thousands of people we could now go back and prosecute if it's within the statute of limitations for the Federal Election Commission, because we could say, oh, you bought that house, that's a campaign expenditure. And to prove the absurdity of this, I will again ask Pisco, which I haven't heard him answer. Does that mean your reading of this would be that I could run for office, get campaign contributions, and use them to purchase a house, as long as I say, well, I purchased the house for the election. I could purchase a Corvette, I could purchase a house, I could anything I want, as long as I say, but for the election, I wouldn't have purchased this.
Yeah, so I'm not here to justify your implicit assumption there that anything that equates to a campaign expenditure you can use campaign funds for.
Can you give me an example?
Hang on a second. I do not know that to be a correct statement of law, that just because you can use that it can be qualified as a campaign expenditure means therefore that you can use campaign funds. Those concepts don't necessarily, in my mind at least, as not a Federal Elections Act expert, those concepts don't seem to be necessarily linked.
The expert weighed in. He disagreed with you, by the way.
So just to be 100% clear, I'm not ready to onboard that assumption. Number one, and number two, again, whether or not it's an expenditure or a contribution, the house, I don't know if the residence that you're using to establish residency to even run in the election itself constitutes a campaign expenditure. I'm just not sure about that. And I told you I'm going to look into the purchase of that house and get back to you. But right now, as I stand here, I'm not willing to make a declaration that just because you're using a residence, you can use campaign funds.
May I ask? I'm sorry.
Yes, you can. Yeah, you can. But I'll give it to you first, right, for this, because I know everyone's got a panel after this, and I want to make sure we cover the 3 topics that I wanted to cover. And the last topic that I wanted to cover, and is probably going to open it up to more than just the lawyers here, right? Will this affect the election outcome at all? So we have had a situation, right, where whether it was lawfare or not, whether he was actually guilty or not, Trump specifically, has been found guilty, right? He is convicted. He hasn't been sentenced yet. We don't know we don't know if it'll come to appeals, if it'll be overturned to appeals. We don't know, but it has happened. Will this affect the upcoming election in November? If so, how so? And if not, why not? Josiah, you can start with your own question first and then get into that, but I do want to bring the focus.
I'll ask my question real quick and then I'll answer. So my question is for Pisco and Lactoid in particular, but Rob can weigh in if he wants. It seems like a lot of the conversation was about one of 3 of potential unlawful means at the 3rd tier of the logic chain. So again, I'm not an attorney, but let's say I grant you all of that there's no case to be made that he knowingly violated federal election campaign law. Well, hang on just real quick. But what about the other 2? Like if the jury says, okay, listen, like if the 12 jurors said, yeah, of those 3, that's not one that we thought that we could make the case for. But what about the other ones like falsifying business records? And I think like some like tax violation, like I can address this. Yeah. Could the verdict still be legitimate by the technical letter of the law if you've only eliminated one of the 3 potential unlawful means? And I'd like the attorneys, but even Rob, if they want to weigh in.
So so we talked about the tax stuff initially. I made my position clear on that. And then we talked about the election finance thing. The one thing we haven't talked about is the kind of middle one, right? The falsification of business records as regards to the steps that Michael Cohen took to acquire the money. I actually think this is the weakest of the 3. I think most people agree it's the weakest of the 3, but I think it's actually so weak that it's reversible to even put it. on the.
When
in
you
the
say
jury instructions.
reversible, you mean like with appeals?
That to have
Yeah.
the instruction, he's basically saying no reasonable juror could have
Gotcha,
come to
gotcha,
the
gotcha.
conclusion.
And the reason why I don't think any reasonable juror could come to that conclusion is because, again, I haven't read through all the transcripts, but my understanding is that no evidence was presented that Donald Trump knew anything about the business records that Michael Cohen was falsifying in order to get that money. And if they tell the jury, you can find him guilty based on this, but there's no evidence in the record put in as to Trump's knowledge or how Trump could have known about the setting up of those business records to acquire the money, then how possibly could the jury have decided it on that basis? And we don't know if the jury decided it on that basis. And if they did, they decided it based on no evidence.
But there is evidence on the record. The phone call that's recorded, you hear him saying he's going to set up an LLC to make and to facilitate an illegal corporate contribution, and that is the illegal corporate contribution of AMI. As I'm sure Lactoid is aware, corporations cannot make election contributions; they're just not allowed to. And you hear in the call that Michael Cohen references he's making an entity to do so. And so I don't know that you're going to win on that argument. It's possible, but again, I'm not saying that there's not going to be a basis here to uphold. I don't think that's the strongest one. I think that there is evidence in the record that suggests he might have actually known about that stuff. The
bigger point, Pondering, to answer your question,
yeah, go ahead, Rob.
The bigger point is, technically you're right? Like if in a normal trial, if you only have to meet one of the three and you meet one, then that would be enough to prove it was an unlawful means. But the problem is if one of the three get tossed out here, because the way the judge gave the instructions, where he said that they did not have to all pick one, that would mean that the case has to be thrown out, and here's why. Regardless of what jurists would say now, they did not put on any sort of official documentation that they were voting or that they were finding him guilty of a particular unlawful means. That means that any reasonable appeal court would have to say, well, listen, if one of these three goes out, we don't know. Possibly one of the jurists found Trump guilty because he thought
he violated campaign.
He violated. And so if it's not there, there would be no choice at that point but to appeal, which I believe, this is a conspiracy theory, but I'll admit it, I believe the judge purposely did that, knowing that it'll be overturned on appeal because... let me restate. It's not that he purposely knew that this was likely to be overturned on appeal, but he did it anyways because he wanted to make it as likely as possible that Trump would be convicted.
Hey, so it doesn't even make sense at all. Like, instead of ascribing a motive that I think is the most likely, which is he's following the precedent from People versus Mackey. That is a case where the same language is in the burglar statute, where, think about this. Imagine there's a burglary, and a burglary is like going into a dwelling, a breaking in with the intent to commit a crime therein, right? The finding in People versus Mackey, this old case from the Court of Appeals, which is the highest New York court, said you don't need to agree on what the underlying crime is when you burglarize. If you burglarize and some of you agree that it's to kill, some of you agree to rape, that's okay. It's a jury instruction. Instead of saying, well, no, they're following the example of People versus Mackey, which seems to be on point. Maybe it's not, but that seems to be the most on point precedent and the most normal. He says it's a conspiracy. It's a conspiracy to maximize conviction while jeopardizing appeal, the fact that it's going to stay with no evidence. And he just told you that there's no evidence, but he believes it nonetheless.
That's right.
That should give you an insight about how his mind operates. He believes things on no evidence.
So we know what the last topic we'll get to is. We'll talk about an insight to how your mind operates. But again, I'd like you to address the main point, which is regardless of what my feeling is, which I admitted I didn't have specific evidence for, if one of these gets overturned, right, and says that wasn't one that was legitimate, you agree that that's justification for an appeal, correct?
If no reasonable juror could have come to the conclusion that the falsification of business record charge could stick, again, I'm not specifically familiar with New York case law on that, but I would think as a constitutional matter, there would be serious concerns. And again, subject to me reading up on the specific case law, I'm pretty sure that would be the result would be vacated.
Sure.
I read that burglary case. By the way, real quick.
Sure, real quick, but then Josiah needs to finish his point.
Yeah.
I think the important thing here is in that burglary case, you still had to prove the mens rea on the person, like who intended to commit a crime.
Yeah, and they had to do that here. They had to do that here, and that's what I guess you're not fully conceptualizing the election law here, and you're thinking that they have to know that the law, that the law is what it is, and that they've knowingly violated it, as opposed to intending the acts that constitute the unlawful act.
So my thing is,
that's necessary for the intent of the underlying action, right? That's what I'm trying to say.
Correct.
Hang on. In order to intend an illegal campaign contribution, do you think you need to know that it is illegal?
If you're falsifying business records with that intent, I would think so. Otherwise, Pisco, think about it's pretty obvious, right? Let's say you don't know. Let's say Trump had no idea whatsoever how this would affect his taxes, even though let's say it would give him a benefit in taxes. Let's say he had no idea about that. Sure, maybe you could charge him under some kind of tax law, right? But how could you prove that when he was falsifying the business records, he was doing that with the intent of committing tax fraud if he had no idea how it would affect his taxes?
Because the underlying taxings requires not that you know it's illegal, but that you're intentionally misrepresenting. That's the intent. The intent is the underlying conduct that is lying on the tax form. That's where the intent comes in, not knowing what you're doing is illegal. If you're purposely misrepresented on the tax, you don't need to show beyond a reasonable doubt that he knew that conduct was legal. You need to show beyond a reasonable doubt that he purposely lied to the IRS. That's where the intent comes in.
Potentially for some. Hold on. Maybe not intentionally.
That's the
lie,
normal
but,
rule.
There could be like a tax violation potentially here. What I'm trying to say is, again, going back to the hypothetical, I just want an answer to this. Let's say Trump had no idea how this would affect his taxes. Okay, he didn't know if this would raise his taxes or lower his taxes.
He knew he was lying.
No, hold on. He didn't. Lying about what?
Did he know he was lying on his for the IRS things?
No. At the time of falsifying the business records, what do you think that he knew that he was lying about?
Because he was representing that this was income paid to Michael Cohen. They took out payroll tax and they structured it on fake legal services for a retainer that didn't exist. And so the question is to you, do you think that if he knowingly lied on that tax form, assume it. I'm not asking you to say that whether you think it is not. Assume he knowingly lied on that tax form, knowing that this was not income and knowing it was a reimbursement. Do you think that that constitutes all the elements of tax fraud and the intent to commit tax fraud, which is an element of tax fraud?
I think if he knowingly committed tax fraud, like if he knowingly lied on his taxes specifically,
and committed tax fraud.
Hold on, then there could be a potentially a charge there. But what I'm saying is, hold on. But what I'm saying is, wait. I'm getting to the meat, and this is what. Don't cut me off. So what I'm trying to, there's like two problems here. First of all, I don't think that evidence was put into place that proved that at the time of the falsification of the business records, this was being done with the intent of committing tax fraud, that he had any idea about how this would affect his taxes, or that he would even lie in his taxes necessarily. And then two, was there any evidence that he knowingly falsified his taxes?
Yeah. So the greater includes the lesser here. He actually did falsify his taxes. That's the greater includes the lesser. But no, when you say knowingly, would you agree that assuming
intentionally?
Hang on a second, Lactone. This is a real quick syllogism. Would you agree that if he knew that this was false and he was misrepresented to the IRS, that he committed the crime of the underlying crime?
If at the time of filling out his taxes, he knew that it was false, but he decided to click on the submit thing anyway on TurboTax.
Yes.
Yeah, sure.
Okay, so doesn't the greater include the lesser? Where are you getting the willfulness standard from? Where are you getting the knowledge?
Because the falsification of business records, in order for that to become the felony, it has to be done at that time with the intent of doing something else. So when he's falsifying those business records, is he in his mind thinking, aha, when I'm going to falsify these business records so I can commit tax fraud? He's not thinking that.
When he is structuring this payment as income, where as a businessman, he would know that they're going to make payroll representations. You're by definition going to be making representations to the IRS. And so for you, I think.
Are you talking about TurboTax?
Did any evidence come in about that?
First of all, there's a ton of evidence about Donald Trump's knowledge about general business practice, his fastidiousness, his sort of attention to detail, all that in terms of Trump.
Could he have forgot?
It is implicit in what when you're talking about payroll income, when they doubled it up for taxes. Remember that little form, the smoking gun, where it says,
well, that wasn't Trump though, right?
I understand that, but it's understood by the players, and I guess you're conceding now that those are false reports.
So I'm working under the assumption that they are false reports.
Would you agree that it is or not? Just for you agree they're false?
I don't know, right? The reason I didn't focus on that is because if it's not the felony, you can't charge for the false reports anyway, because the statute of limitations is gone, so it's legally moot.
Whether it's legally moot or not, it's one of the elements of the felony is that these are false. You agree they're false?
Probably, but again,
Okay.
like the question in my mind is like,
know.
hold on, is it common practice to reimburse attorneys for NDAs under legal services? Maybe.
Answer no. No.
Hold on, maybe.
You're a lawyer. You know that's not. Hang on. You're not gonna. No. This is what's crazy, right? You know.
I'm not a New York lawyer. Shit's crazy over there.
You know that if you're paying a reimbursement, you're not going to get taxed on it. Why would you, as a business, tax yourself?
I agree that it was stupid, but I think the fact that it was
But
stupid kind of.
Let him answer the question.
Yeah, the fact that it's stupid, I actually think sort of goes to the argument that Trump didn't do this with the intent of committing tax fraud. Because why would you lie? Why would you falsify records with the intention of paying more taxes? Like that,
because he's willing to pay.
I don't think he was thinking about that.
Because he's not dumb in that respect. He is willing to pay more to hide it. Otherwise, you're saying he just wants to structure it this way because he doesn't know anything about tax. But it's clear that they know about taxes. These are wait. Just one last thing. For evidence of this, Donald Trump, I think, has literally said, "No one knows more about taxes than me. I do all this taxing." I think he's literally made the lactoid. He has literally.
He said that about everything.
Okay, no, I'm throwing a flag on the plate above you because you're circling the drain, and we're going to go for the next 30 minutes. We have a hard cutoff here because you have other places to go. I know Rob has his 10 minutes he wants with Pisco on the Bowman thing that I want to make sure.
Oh, I'm not going to give that to him. No. Yeah. So to be 1,000,
here he is, Coward Pisco. Go ahead, tell us how you're running.
To be 1,000%, 1,000,000,000% clear, everyone on this panel prepared for a discussion about the Donald Trump cases and the implications on corruption. For Rob Noor, big baby that he is, to turn this conversation and disrespect the audience, the panel, and the reason we're here by sort of executing on a vendetta that he has about me on some totally irrelevant matter, is beyond the pale. I refer everybody to our previous conversations about Jamal Bowman. The matter does not need to be discussed any longer.
You can run. I will talk to the audience. You can run if you need to run.
That'll be the last 10 minutes, regardless. That'll be the last 10 minutes. Until then,
you'll hear a screed and some convoluted thing about Bowman
because he knows he's wrong.
So
and
here
to answer important to bring up, because we just heard Pisco go why it's not important. You remember when he asked me earlier when he said to the audience, "See, this is the type of character Rob is." You remember when he said that? Now we're talking about different concepts. We're talking about different concepts and interpretations of the law. And you've heard Pisco say various times he disagrees with the biased former FEC chairman that says that this was it. He disagrees with him.
So Rob's going to make a case against Pisco's bias. Rob, let me, because that way you guys can go at it afterwards.
That's fair.
Yeah, I'm not going at it. Rob can.
That's fine. That's fine. Whatever. So to answer the question about the impact on the election, I think it's too soon to tell. So a couple of things. Reportedly, I don't know if this has been confirmed yet, but Donald Trump raked in a fuck ton of money in the 24 hours after the conviction, small dollar donors and things like that. He's been lagging behind President Biden in terms of fundraising. This could close the gap. We'll see what happens. We'll see what Biden reports. On the other hand, the consistent polling post-conviction shows it's a tick towards Biden or a reduction in Trump's favorability. So, but again, it's too soon to tell. I think that the general conception is whether or not you think that the verdict here was legally valid, it is considered by far the weakest of the cases against Trump. And I think that it will have the least impact on this. But also, to be clear, because this election will undoubtedly be razor thin, if Trump loses support on the margins, it will cost him the election. He has to maximize. He's never won the popular vote against any of his peers. So he has to overperform in terms of support. He has to win back swing states that he lost from President Biden. Biden has a greater margin for error in terms of what he can lose. But Trump also has been consistently pulling ahead. I still think this election is a wash as of right now. And there's evidence either way, depending on which metric you want to use, fundraising versus polling. That's my position.
It's election interference. That's what it is.
Any other thoughts on that?
Yes.
Gibbs? Go ahead.
Yeah, so I think it's basically everything just Pondering Politics just said
No,
here.
you got it.
Is
But Bibbs, you can use
Josiah.
my name. Yeah, you're
Yeah,
good,
I
buddy.
appreciate it. Yeah, but you're gonna laugh at the anything I have to say here. But like, yeah, I definitely got to say, absolutely, he's correct. He had the website crashed. 54 million was reported in the first 8 to 24 hours. 6 points up in polling. I gotta say, when I went out there clubbing this weekend, probably a bad idea considering my eyeballs, but I'd never seen so many people so quickly get mugshot hot T-shirts from his last one that said "Free the Dawn" and like walking around. People I knew that were like hardcore Democrats their whole life suddenly were saying, "We're gonna vote for Trump. That's someone we want. They're out to get him." Yada yada. Now, I do want to add one thing before I turn it over because I know this is probably the last time I'll get to speak here. I would like to point out one thing. I never want to hear anybody, especially my conservative friends, say that Wick doesn't get a fair shake because we've had some conservatives talk a lot here tonight. And I did do it on a hunch after openings. I should have done it for Rashad too, but I didn't. I started timing my time and Josiah's time here. And Josiah came in before his last statement with a whopping, of all the time we've been here, 4 minutes and 37 seconds of talking. And I had a massive 5 minutes and 43 seconds. So if anybody thinks I'm a blowhard, I just want you to know, y'all can all suck my dick. That's bullshit. But Wick let everybody else talk. I want to say that Wick was very outstanding as a moderator. He definitely let the people that were the most
You don't have to
impassioned
suck my
go.
dick. Though. You can
And
just-
no, I'm not sucking you. I'm saying this is a bullshit. I want remediation. We're suing for slander now. No, I'm just kidding. But yeah, so
Let me
4
ask.
minutes 37.
Let me ask the
5:38.
lawyers real quick to answer this question. Just real quick, and I'll get to my answer. Is a violation of due process unlawful?
I think by definition, Constitution is the supreme law of the land. You violate the Constitution, you violate the law.
Okay, then I would argue that if Donald Trump wins election, Alvin Bragg and his prosecution team should be prosecuted under 1715 too, because they have affected the election using unlawful means. If this is overturned on appeal and it turns out that Trump received due process violations, for which there are grounds for many, would you concede, since you've conceded it's unlawful, that that was a group of people, the prosecution team, that came together to affect an election and did so under unlawful means by violating his due process? And would you support Alvin Bragg and his team's conviction?
No, absolutely not. I think it would be preposterous to think that you could meet the intent requirement that they knowingly, and in this case, knowingly violated his due process.
No, they only had to take the steps that they knew would constitute what that's what you just said on tax violations. That was your interpretation.
No,
they
but
don't have to know that they were violating his due process. They just had to knowingly take the steps to violate his due process.
So there's a big misunderstanding. So one thing is the underlying actus reus, the thing that is the tax violation, is the lying, not the knowing violation of the law. That is what.
It's the opposite.
Why are you telling me that's not true? So you think that, again, I just had this exchange with Lactoid where he admitted that if the facts I said were true, that Donald Trump would have committed the actual act of tax violation. And the only reason why an additional mens rea would be required would be because of this election statute, the way he's interpreting it, which we'll look into.
Yes, I agree with that.
But that is not at issue here because, or sorry, the underlying act itself, which is the tax violation, is the lying. If you're saying that someone is,
that's not true.
Hang on a
second.
second.
Wait. Explain yourself.
What do you mean that's not true? Yeah.
You're saying not that the lying's what constituted tax fraud. The tax fraud's the tax fraud. You're saying the intent to commit tax fraud, it's the lie that's the intent.
Intent to commit the acts that constitute the tax fraud in terms of the lying to the IRS intentionally. Okay. And of course, the way you're still gonna have to prove that they lied knowingly, and that's obviously going to be with, that's the burden of the prosecution to do. But with a due process violation, you have to know that they intend to violate their due process.
I disagree.
Rob, but I want to hear Lactoid's answer to your question as well. I'm very curious.
So again, Pisco will say this is not what he's saying, but it sounded to me like he was saying with the tax fraud violations when Lactoid brings up the idea of intent. The argument isn't that Trump had to know the tax laws and intend to violate the tax laws. It's that Trump did violate tax laws and he intended to take the steps that did violate them, regardless if he knew it was a violation or not, correct?
That he intended to knowingly, maliciously lie.
No, that's not true.
So here the equivalent would be...
Let me finish. Yeah. What you're doing is you can never just answer a question yes or no. You're saying the lie is what constitutes the fraud, correct?
The lying to the IRS about...
So another way of saying what you just said would be that he didn't have to intend to commit tax fraud. He had to intend to take the steps. In this case, the step was a lie. And that's why he has intent.
Right. So
You can't
like,
answer yes or no. I know.
So hang on a second. So the equivalent here would be if Alvin Bragg knowingly deprived Donald Trump of his due process rights, knowingly, then I think that might be grounds for, to affect the election, that might be grounds for a violation of the statute.
But
I don't
why
think
is it that that's not true? He doesn't have to understand what the law is on a due process violation. According to you, he would only have to knowingly take the steps that were a due process violation. You have no argument why that's not the case.
Yes,
You have
yes,
none.
yes.
No, you don't.
Lactoid will agree with me because Lactoid knows that there's no strict liability as an assumption for criminal laws. He understands. The kind of thing that you're proposing, Rob, would be strict liability for violating due process. Which, of course, if that were the case, then there are a lot of due process violations that Donald Trump was found for and for Biden, but it's not the case. And there's also
you're wrong.
Yeah, but let's see what Lactoid has to say.
He's going to agree with me. He's about to agree with me.
Well, Pisco, I think what you're missing, what Rob's trying to do right now is he's trying to point out a perceived inconsistency on your behalf.
Yeah, but he's failing.
You can think that, right? But what he's saying is that, my position is, and the position we've had is that there needs to be some kind of intent to commit another crime. But you're saying that, well, no, he needs to have done this and then with the intent, well, not even that. He has to have done this and then intentionally done something afterwards. It seems as though that's the point you're making.
Let me
you can disagree with the. Well, I want to finish. You can disagree with the characterization of that, Pisco, but that's what he's trying to do. In terms of the actual question as to whether or not they should go after Alvin Bragg, I think I can be consistent here and say, I think that you would have to find. Look, do I think that the judge is biased? Yes, he violated ethics codes to donate money to a campaign against Trump. He should not have done that, and that's a problem when that judge is now deciding things for Donald Trump. You have Bragg, who has absolutely, is of course biased, right? And now, just because he's biased doesn't necessarily mean that I think that he should be criminally prosecuted. I would agree with Pisco that in this case, you would have to show that he intended to go after Trump unlawfully. Now, I think the point you're making, though, is that maybe I can hold that position consistently because I also think that Trump, in order to show that he intended to commit another crime, that you have to show the mens rea there, and then to commit the crime. And you're saying Pisco is being inconsistent because he has a different standard for Bragg as opposed to Donald Trump.
Pisco's argument is this, and he's trying to weasel out of it, but his argument is this. He didn't have to intend to break tax laws. He had to intend to do the things that constitute the breaking of the tax law. So in this case, the lying, the misrepresented. He may have done that and not known that that was a violation of tax laws, but the tax law says if you lie and misreport, it's a violation. So all you have to do is prove the intent that he took the actions that would constitute a violation of tax law, which means that it doesn't matter if he knew. I don't see a reason that Pisco's differentiating why that would be different here. And I'm pointing
I will
out
give it to you.
Let me finish, right? And so the argument would be, if an appeal court says clearly Alvin Bragg violated his due process rights by not including the specific underlying charges in the indictment, or through several other arguments that might be said that the prosecution violated his due process, the argument would seem to entail then, well, Alvin Bragg didn't have to know that was a violation of due process. He just had to know that he was taking the actions that would then later be determined a violation of due process. Did he know that he was not including, in this case, the specific underlying crimes in the indictment? Yes, he clearly knew he was taking that action. He'll say, oh, but I didn't think that was a violation of due process. Just like Trump could say, oh, but I didn't know that was a violation of tax law, and Pisco says that doesn't matter.
Okay, we're gonna hold on just before everyone goes, because again, I want to make sure that the time we end and we give everyone the time they need. So after you respond, Pisco, what's going to happen is we're going to go to closing statements, and then after that, we're going to give, and you can stay, and I invite you to, and I hope you will. We're going to give Rob those 10 minutes that I promised him, because I'm a man of my word. Have the floor, right? To talk about the Jamal Bowman and Pisco stuff.
Yeah,
he
wanted
to
go
do.
at
You
his
were
will.
Stay.
I understand that. Yeah,
you don't have to. Okay.
Okay.
So respond to that. Closing statements. Then yes.
So the normal rule, as everyone understands, is that ignorance of the law is not a defense to crime. You cannot say, for example, I didn't know murder was illegal. I didn't know, depraved heart, whatever, driving drunk was illegal. Ignorance is not an excuse to the criminal law. When I described that, Trump didn't need to know he was breaking the tax law, although I think that there'd be sufficient evidence to conclude that he did know that he was violating the tax law. So even if what Lactoid was saying is true, I would still think that he's guilty. But if it were all I was doing when I was describing that is describing the normal presumption, that presumption being ignorance is no excuse. With respect to this new theory that Rob is proposing, the underlying act would be a deprivation of due process rights. And his distillation, where it would include Alvin Bragg's prosecution to be consistent, does not include a knowing component, or intentional component. The tax violation still has a knowing and intentional component, even taking out the ignorance of the law. And what what Rob is describing is a kind of crime where the underlying bad conduct is the knowing deprivation of due process. And I would agree, if Alvin Bragg knowingly deprived Donald Trump of his due process rights to affect the election, that probably should be considered under that statute. But absent that, there is no inconsistency in a crime where the actus reus are these intentional lies, and another crime where the theoretical actus reus would be the knowing deprivation. And so there's no inconsistency. I'm just applying normal rules.
He conflate. I'll just say real quick here, right? Like, there is entirely possible that there are legitimate reasons and issues on the books that say you can't go after prosecutions and things like that. That I understand. But in the exact way that Pisco is saying, how we would apply this, that if Trump didn't have to know, ignorance of the law and all that, we get all that, he didn't have to know that he was breaking the law. He had to know that he was taking the steps that would be a violation of the law. That's all he had to know. And so the question is, did he know? Because if Trump stands up and says, I didn't know that was a violation of tax law, Pisco is going to say, it doesn't matter. Lactoid says, but then he didn't have mens rea. He didn't have intent to break the law. Pisco says, it doesn't matter if he had intent to break the law. All that matters, he had intent to take the actions that constituted breaking the law. Pisco can, like he says, but there's no knowing. There is knowing. Pisco, yes or no? Did Alvin Bragg know that he didn't include this under the unlawful means in the indictment? Yes or no?
So again, that
Can't
unlawful.
answer. He cannot answer.
So it was his. It was
Pisco
his
can't
belief.
answer.
It was
he can't
his,
answer. Now
it
he's
was
going to give
his
another
belief.
closing statement on
It was
this.
his
Right?
belief.
So we're going to go.
It
He
was
can't
his
answer.
belief.
He cannot
Damn it.
answer.
Okay.
It was so he
cannot
understood.
answer.
So Alvin Bragg reviewed. So just to be clear, Alvin Bragg reviewed his own indictment.
He can't
Alvin
answer.
Bragg, Alvin
he
Bragg,
can't do it.
Alvin
Cannot
Bragg,
answer.
Alvin Bragg
Pisco
knows.
cannot answer.
Alvin
This
Bragg,
is classic.
Alvin Bragg.
Why would he say no?
So I'm
Why would he say
answering
yes?
his
He
Stop.
can't answer. He can't
I'm
answer.
answering his
Stop.
question. I'm not going to
Stop.
pigeonhole him.
He can't answer.
Stop.
Yes or no? Then you can expound.
No, everyone stops. Everyone stops. Okay, cool. Good. We good? If we keep going this all night, you guys aren't going to get to your next appointment. So what we're going to do is we're going to closing statements, and he can address this in closing statements. Because,
I will.
by God, we do need to end this. We do need to end this. And I guess we'll start with Pisco, and we will end with Gibbs. So Pisco, floor's yours. Closing statements, motherfuckers. Don't interrupt.
To answer real quick, yes, he knows what's in his own indictments. The question is whether you know that constitutes a violation of the due process, different than, because a criminal intent is assumed as part of a crime, that you have to have a knowing intent, an underlying actus reus, different than the underlying tax violation, where the bad act, so to speak, is the underlying line. Here, as a matter of course, prosecutors violate due process all the time. How many, and Lactoid will tell you, how many times are like criminal appeals overturned, criminal convictions overturned because of due process issues? It happens as a matter of course. You're always arguing it. No one has ever argued, and it's never been the case, that a non-intentional violation of due process constitutes a crime. That's a completely brand new theory that absolutely is not apples to apples with the underlying crime of intentionally lying to the IRS, which by itself is a crime regardless if you know what the tax code is. I can't explain it any more than that. That's just the way it is. As for everything else, I mean, it's kind of pathetic. The Republicans or I should say the MAGA conservatives, or whatever you want to call them, the anti-Trump indictment
kind
or
of make heads
conviction
or tails
people,
of that, but then
practically concede
so we heard from
elements of this
said
case.
that
They
McCarthy was
concede.
doing that tactically
Rob straight up
because he
conceded
had to get
that
a loan
these are
reporting.
false
Also
statements when
suggested
he
a debt
made that error about the
default if there was
reimbursement
not
and
some
accused
type
of
of a
Michael
deal.
Cohen, if you remember
So
that.
you can take that for what it's
Lactoid
worth.
said
You can
that
decide
yes, it's probably the
McCarthy
case
is not
that
credible or
these
that
are
he
falsified.
is, but that's
They disagree for some legal reasons about having more to do with the comparisons to the Clinton case. I will look into the House case. The comparison to the 2016 stuff is a non-starter. It's not at all comparable. But on the actual merits of the underlying purpose, they can't really contend with the fact that this is clear as day a violation of tax law. Can't really contend with the facts that if you look at the evidence in this case about what the purpose of this payment was, and that this was in fact a loan, that it was for the campaign. Again, I agree that the underlying business records thing is the weakest of the cases, but I still think that that was proven beyond a reasonable doubt as well. And so altogether, what do you have? The fundamentals of this case are not contested that hard. And the real arguments are, do you believe the Hillary Clinton House case is comparable? And do you believe the 2016 Hillary Clinton case is comparable? That's what it amounts to. And so on that note, I think that practically everyone should agree that Trump committed some crime. And the question is just, should we have charged him with it?
Thank you for being here. Really appreciate you. Rashad.
You can follow me at Rashad Crenshaw on YouTube. I definitely did not win. I did not go and study law before this one, so definitely should brush up a little bit more. Found some holes in my game with this debate, so wasn't able to participate as much as I wanted to, but I was able to realize there's levels to this shit. So thanks for everyone participating, and I definitely learned from the main screechers in this debate for sure.
Well, thank you for being here. I appreciate you. Rob Nork, go ahead.
So there's 3 levels of this case, as I said the first time. Was this a selective political prosecution? We didn't get to talk as much of that as we wanted. Then there is the second level of, do these legal theories hold water? Were there due process violations? Didn't talk a lot about that. Then the third place was, is Trump actually guilty if we get through those first 2 bars? Now, I admitted that I haven't read the vast majority of the transcript. In fact, I've read hardly any. We're taking for word Pisco here saying that he has read the relevant parts. I think some people would disagree with him, but I'm not prepared to go back on what Hope Hicks said or this or that. I don't know the specifics of that. I think that is the far least important issue that we're talking about here. The idea of like, for example, I haven't heard any proof that Trump knew how this was titled, like the idea of how these payments were titled. I don't know, but it's not the particular issue that I'm interested in. It is self-evident to anyone's watching that this was a political prosecution. This basically is tantamount to a paperwork error. The big bad tax violation led to Trump paying more in taxes. The big bad falsification of records for election interference comes down to what the prosecution said in this case. Who knows? Perhaps Hillary would have won if we heard about Stormy Daniels, forgetting the fact that, perhaps she would have lost even more if we knew that they were telling the truth about their actual FECA violation that they had previously. The whole case is a farce. And like I said earlier, anyone who could look at this and not see the first time ever that we're going after a former president and the and the contender for the political opposition party is this paperwork violation. This is what we're going to go for. And it just goes to show that this is what all of these charges were about. We haven't even gotten to questions of, can a state level prosecutor charge federal crimes? For example, one of the issues I wanted to get to, I don't know, I would like to hear lawyers' response to this someday. In Colorado, marijuana was legal at one point. So if you bought marijuana and wrote on the check something else and that was a false business record, could under this same theory, even though the state prosecutor couldn't charge you for marijuana, could that prosecutor say, but you wrote the wrong memo in the check, you said it was for something else, and it's illegal to have marijuana federally? That seems to be ridiculous. What this allows is state prosecutors all over the country to prosecute federal crimes, which is nonsensical. The Hillary Clinton part is important, and I know it'll be wiped away. 1/3 of the people listening, probably more than that, are hopelessly partisan. And the truth is, when you get right down to it, people like Pisco and Pondering are going to be okay with this because that's their entire worldview, that orange man bad. And so they'll make any justification for any double standard whatsoever. But for the rest of you listening, this is the most important part. Was this a political prosecution? These prosecutors, Cy Vance and Bragg, looked back to the 2016 election 6 years earlier and said, did they put the right lines in their payments? Did they? We need to subpoena records. We need to find out. Meanwhile, they already knew Hillary Clinton had violated a FECA violation and the Federal Election Commission had ordered it so. Yes, it was civil and didn't rise to the level of criminal, but if you look at the facts of the case, it's obvious that she falsified these records. Pisco's only argument to this, his only one is, but it's not as bad as what Trump did. I gave reasons why I think what they did is worse than Trump, but it doesn't matter if it's as bad or not, because he's making the argument on the tax portion of this. Well, it doesn't matter if Trump paid more back in taxes. The law is the law. That's the law, and we have to. The law is very clear. The federal election laws. You cannot falsify your disbursements. You have to say who the recipient of your disbursements were, and you have to give the proper payment that why they were being paid. And Hillary for America violated those twice. She did so in New York. These constitute business records, as Pisco was unable to answer. That means that that Vance and Bragg had every reason, if they were interested in looking back to payments in the 2016 election, saying, "Hey, if we're going to look at Trump, we should look at Hillary too." But they didn't. They didn't do that. And so basically what happened is Hillary's team is fined $130,000 for the same crime that Trump's looking at 130 years for. And it's been put off, and it was put off to basically affect the election, and it is election interference is what they're doing. And so we didn't get to a lot of the most important parts of this case, but I'm happy when I get to talk to lawyers to try to talk in the areas that they think that their expertise on. I think me and Lactoid did a fantastic job of arguing why this would be bad to say it violates Federal Election Commission, and I think that I'm going to take the word over a Federal Election Commissioner like Brad Smith and the fact that the FEC looked at these payments and didn't think there was a violation over the words of someone like Pisco, who, as we'll get to in the next segment, you can see where his bias lies.
Okay, well, thank you for being here. Really appreciate you. Okay, yeah, Lactoid, go ahead.
Yeah, so my perspective on this is that it seems like with this trial specifically, people who are in favor of Trump getting convicted, Democrats generally, they like to appeal to common sense with a lot of things, and they dismiss the objections as appealing to technicalities or appealing to legal technicalities. But the problem is that there does seem to be a little bit here of trying to have your cake and eat it too, which is that, for example, of course Trump was committing tax fraud. It's common sense. Look at everything, look at all of his expertise and everything that he knew. Well, but like, what about potential bias from the judge who donated money against him? Well, we don't technically know for sure if that influenced anything. What about Bragg, who campaigned on the fact that he was going to, sue Trump 100 times, or that he had sued Trump 100 times, that he was going to go after him? Well, potentially, but we don't know how much that had to do with it, really. What about the jury being biased in one of the most blue districts in the country? Well, potentially. I mean, one of the jurors, got their news from True Social. So, I mean, how do we really know? You're right. I mean, technically, we don't have unshakable evidence for a lot of the objections. The problem is the entire Trump conviction is based on technicality, and any application of common sense is devoid. An expense to silence Stormy Daniels, which Trump had apparently been pursuing since 2011, is obviously a common sense. It's obviously related to his 2016 campaign. But the Clintons openly buying a house in 1999 for the express purpose of running in New York in 1999, well, you can use a house for other purposes. I don't really know. I mean, technically, we don't really know if this is, again, it's ultimate charity one way and ultimate skepticism the other way. And I think at the very least, even if you disagree with all of the legal arguments that I've presented, and you agree with all the legal arguments that Pisco has presented, the fact that, looking at the trial from the beginning, looking at how this has never been done before, just looking at some of the absurdity that, in terms of how we have to look at, well, technically it was past statute of limitations, so then we did this to bring it back. And, I think it's pretty clear that there is bias at the very least. Now, I don't think this is like being directed by the Biden campaign. Perhaps some people do. That could be, maybe upper level conspiracy theory. But I think it's absolutely true that there's a lot of people on the lower level, even down to the jury, where, we have a very contentious human being where everybody has an opinion. And a lot of people, especially in New York, hate this guy. And they hate him so much, and they think that he's a genuine threat to the country. You hear them say it. They say that he's a threat to democracy. Well, what do you do when it comes to a threat to democracy? Sometimes you got to twist the rules to get rid of that threat to democracy. And that's what I think happened here. If you like what I had to say, you can find me at Lactoid TV on Twitch, Twitter, and YouTube.
Well, thank you for being here. We'll get to it. I want to get through these quick, right? I want to give you all equal time, but I know Rob has a place to be, and I did promise him 10 minutes. So please, Josiah.
Hey, everybody, you can find me at youtube.com/@ponderingpolitics. I am glad that there were attorneys here on both sides being able to litigate the case. That was one of the things I told Wick when we discussed the panel. I'm like, it's really important, since this is a matter of law, having the attorneys. I'm with Rashad. I don't know nearly enough about the law in this case to be conversant in it, so I just ask questions. I appreciate the answers from, yes, Pisco, obviously, but Lactoid and Rob as well. Whether or not I'm partisan, yeah, unapologetically so. I don't believe that Rob is nonpartisan. I don't believe that there's an investigation that Rob would ever tolerate into Donald Trump. We can have that conversation at a separate time. I don't think anybody is truly unbiased with respect to Donald Trump. he has ample grounds to appeal from the sounds of it, and this may be vacated on appeal. I'll accept the results from that. As far as I'm concerned, this is the weakest of the cases. Yeah, that's basically what I have to say. I do want to talk to Pisco about that thing the last time you and I talked, motherfucker, about judges and recusal and things like that. And the last thing I'll say on that score is the one thing I will say in Mershon's defense is the fact that this ethics situation was reviewed by a higher body. So that's some level of due process and accountability with respect to his bias. As somebody who wants judges to be like androids when it comes to the recusal process, be it people like Mershon or Supreme Court justices, I think it's perfectly reasonable to call in Mershon's objectivity into question because of that $35 donation. But again, at least there was due process involved where that whole thing was reviewed, unlike somebody like Justice Alito, by the way, whom we're supposed to trust entirely at his discretion. Lactoid, I want to have a conversation with you as a follow-up.
It was his wife, you sexist.
You motherfucker. We're going to have, this is my closing statement. I do want to have a follow-up with you about that sometime because I do think this is fascinating. And I would love to see eventually some sort of debate between some of the biggest legal analysts on this issue. So Ellie Honig from CNN, Andy McCarthy from Fox News, Andrew Weissman.
Send him my way.
I would love that. And if anybody has any like high profile debates on this issue, that would be really good reference point as well. But again, you can find me at youtube.com/@ponderingpolitics. Thank you.
Thank you for being here. Really appreciate you. Gibbs.
Oh, and I'm sorry, real quick, just again, Pisco, when this is done tonight. Yeah. Okay.
All right, yeah, don't worry. Listen, I didn't have much to say on the panel. I won't have much to say now. Listen, as an American citizen today, your life would go better if you took every penny you owned, invested it into cocaine, and gave it to Charlie Sheen the day he got out of rehab, than it would be to be a political opponent of the Biden crime family. This is a clear farce. It's evidence of outrageous corruption by the Biden crime family. They're running rampant. They're stopping their political opponents. They can't stop him during their campaign because he can't remember his words on the prompter. So they're going to stop him in the courts with made-up bullshit. That's the bottom line because Papa Gibbs said so. Y'all have a good rest of y'all's night.
Thank you. Okay, I know the rest of you have to go. You can stay. Pisco, more than welcome. And I know we're gonna give the floor to Rob for at least a little bit.
Pisco, ping me when you're ready, buddy.
Pisco's gonna leave. That's fine. I only need a couple minutes.
Thank you so much, Wick.
All right. We'll see. I don't even know who's still here. That was a thing. That was absolutely a thing. Here, let me call Pisco because he is ready to talk. Hang on one second. I'm putting you on hang on one second. Let me do this. Let me take the camera off. Let me put the camera on. Turn on the camera. Oh, shit. It's doing that thing again. Okay. Yeah, you can be... I will not be on camera, unfortunately. I'll be on stream because I disconnected the call. But I have you on my stream while we're talking. So
so they can see you and me, right?
They can see you and me. You can't see me, but they can see and hear us both.
That's cool because I have your chatters on the other panel, so we're good.
Oh, okay.
What did you think? I was extremely happy because I thought that Rob might bring up the point about the theft with Michael Cohen, which only works if you agree that this is not a payment for legal services that happened in 2017. And so his admission that he thought that Michael Cohen definitely stole from Trump was an admission that Trump definitely misrepresented and
right.
false false business records. And then essentially admitted the campaign purpose of it. Maybe not I think he was, and they were incorrectly worried about the parade of horribles of like what happens if, brushing your teeth is technically a campaign. I think they have the law wrong there.
Well, I think you made the case with the but for. You'll probably brush your teeth or take a shower regardless if it's beneficial to the campaign. So I think that's a fair case. I also think it's fair to point out though that you want to review the Clinton thing because
I think it's a weird one because as for the House, it definitely could have been just for the campaign or after the campaign. But I'm wondering whether fulfilling like legal residency requirements.
Right. That's what I was thinking.
Yeah, it just yeah,
right. They
I
have to.
heard
He
about
has to leave. They have to
yeah.
legally reside because she was running for Senate at the time.
Right.
I don't think
So
they
it's like,
legally resided in New York. So that and there would
Yeah.
have been, because she was running for Senate, she could have lived anywhere in the state. Right. So it's not like she had to
Right.
buy. It's not like she lived in New York but had to purchase a house in a specific area of New York. Right. So to me, I think it was probably more of a legal requirement for residents more than
Right.
anything else.
Well, but I don't know if that's an exemption or what's going on with that. So I will definitely look into it. But it just-
That would,
it
I mean,
strikes-
you're the
it strikes
lawyer,
me as
but
so odd.
you're the lawyer, but
Um,
it would almost have to be an exemption, right? Because
Yeah, I just don't like
Yeah.
people buy houses to fulfill residency requirements. And I don't think that suddenly makes all of campaign finance law moot. I
Right.
mean that's really and it's kind of the same deal with a lot of these like sort of the Espionage Act cases, the obstruction cases, because you can find some cases which are more unclear, where it's like more marginal or whatever. What they want to do is have it so that you should never apply it, right? That's ultimately Rob's standard is no standard. He claims he never wants this applied ever, right? That it's just so stupid to apply mishandling. You just never do it, or it's just so stupid. I would never agree with federal election campaign violations. But that's just an excuse not to think. And so I will look more into the House case, because something just strikes me as odd about something done for the purpose of filling residency, whether that could possibly qualify.
Yeah, here's what I'll say on this. I think that the panel, I mean, I'm with Rashad on this. And this, by the way, just FYI, I mentioned to Pisco months ago that there should be a panel about just the broader philosophical and political context of the so-called weaponization of justice, because this is something that both sides are alleging. I mean, Democrats, I think correctly, have been complaining that Republicans have sought to weaponize, I mean, explicitly, Trump has campaigned on it every time he's run for president. Of course, they have their opinions about how Democrats have weaponized justice. So I thought that it was really politically relevant. But the second that I knew it was going to get into the mechanics of this specific verdict, I told Wick, I said, we have to have lawyers on this panel. Not on one, like it can't just be Lactoid and it can't just be you. Like both sides have to be represented by counsel, so to speak. And I just knew there were some questions I wanted to ask. Like, again, to me, the intent thing, I still struggle to understand, given that the three layers,
I'd like to clarify that even more. So, as I mentioned, right, the underlying rule is ignorance is not an excuse for criminal law purposes. There's another underlying assumption, which is you need to have intentional. What's criminalized is intentional knowingly, unless it's like a carve out exception, such as like reckless murder, those kinds of things that are known in the common law, or if there's a statute, it like specifies what the mens rea is. So it's typically the case that ignorance is not an excuse, and that there is an intent, like a kind of mens rea, intentionality, criminal intent component to the law, and that's usually a high threshold. You need to show beyond a reasonable doubt that you intended to commit an act, like a criminal act, not that you intended to break the law. Notice how there's different, like intending to break the law isn't the same thing as intending the crime, right? Think about the willfulness statute in the Espionage Act that Biden was considered for. In the Espionage Act portion that Biden was considered for, you need to actually prove that Biden knew what he was doing was illegal, right? It's not enough for him to knowingly retain classified information. You need to prove that Biden knowingly retained classified information, and he knew that doing so was against the law.
That he knowingly kept the documents and knowingly knew that by keeping the documents he was breaking the law.
breaking the law.
Yeah.
That's a special statute that has an increased mens rea. It's called willfully, right? Willfully withheld classified information. That is, and not all of the statutes have it. There's another example of it where, for some of the gun laws, where if you buy something from a certain place and it's not registered, you need to know that you're breaking the gun registration laws before you can be charged with it. And there was an amendment to that. So that's the case law on that. The hypothetical that Rob was presenting, let's start first with Lactoid. Lactoid was saying, well, don't you need to prove that Trump knew that what he was doing was against the tax law. Number one, I think that could be proven, because I think that beyond a reasonable doubt, you can prove that Donald Trump knows that purposely lying in a tax form is against the law. Like, so even if you accept that we had this kind of heightened know that what your conduct is illegal, otherwise you can't be convicted, I think Trump meets it. But even beyond that, I don't believe at all that you would need to show that he knew his conduct was illegal. I think what you would need to show, my strong belief is, that he knew he was lying, and that's what you need to show. It's not
so that's the thing I want to clarify real quick before we turn to some other things. So my understanding, first tier, he falsified business records.
Mm-hmm.
The second tier,
with the intent to conceal.
Yeah.
The second tier.
Yeah. The second the second tier is by conspiracy to promote or prevent the election of a public official, right?
By unlawful means.
Yeah, by unlawful means. That's the third tier. The unlawful means could be a finance law violation, falsifying tax records. I can't remember what the third thing was.
Yeah. So think about it this way. So like, let's say that you could show that you falsified a business record to promote or whatever a candidate by unlawful means, and the unlawful means were killing the candidate, right?
Mm-hmm.
And say for whatever reason you can't charge the actual killing. That's why you're going with this, right? There's some legal defect to charging you for the actual killing of the candidate, but you can, for whatever legal reason, charge them for the false business record done to promote a candidate for unlawful means, and those unlawful means being the murder of the opposing candidate. What Lactwit is saying is, under his theory of it, you would need to show beyond a reasonable doubt that he knew that murder was illegal.
So can I focus on this part, because now I'm trying.
Yeah.
I think maybe I'm grasping at it. So the language is conspiring to promote or prevent the election of any person to a public office by unlawful means.
Mhm.
The unlawful means is a violation of the Federal Election Campaign Act. One thing,
Yes.
real quick: did Trump violate the Federal Election Campaign Act, given that the payments to Stormy Daniels exceeded?
No doubt, and I'll tell
Okay.
you how. Two ways.
So even it, I'm sorry, just to really be clear, because I'm not an attorney, as a layman.
Yeah.
Is the sum itself exceeding the threshold, the violation, or did he have to knowingly violate the threshold by cutting? Like, if I'm in Trump's position,
Yeah.
if I cut the check for $130,000, even if I don't know,
And let's say you think that the campaign limit is 30,000, right?
or that,
sorry, 130. You think that what you're doing is
yes,
legal.
correct,
Yeah,
yes.
the typical rule would be that you are the ignorance of what the campaign limits are.
That's the
is
point
not
you
an
were making.
excuse.
Gotcha.
Yeah.
So that's the point you're making. It's like it doesn't
You
matter if he
intentionally made the
intended
payment.
to violate the
Yes.
financial election campaign, or excuse me, the Federal Election Campaign Act. It doesn't matter if he, like, calculatingly, I know that the sum deliberately exceeds the threshold. It did,
Right.
and he cut the check. That is
Yeah.
the unlawful means, period. And then we go back up.
Now, as it happens, like,
Okay.
if it were a genuine mistake, I doubt, like, they probably would have charged, and there could be other issues in proving
Sure.
that. There could be other issues if this was a genuine mistake. I don't know that it would be charged, convicted. But as it happens, even if I'm wrong about all that, there's ample evidence to show that he knew that this was not legal, and that is the cover up, right? Why
Sure.
would you, if you thought this was legal, why wouldn't you report it? So
Right.
even if you thought that, like, this was legal, and it's kind of like a recursive circle, because you'd be like, well, he didn't think it was lawful that he had to report it, right? And so you understand why this ignorance of the law thing is not typical, and it's this heightened standard, because then you're like, well, I didn't know murder was legal. I didn't know that you had to submit everything. Like, we rely and we impose an obligation on our citizens as a matter of course to be aware of what the law means and what it says when you're doing, like, relevant conduct, right? It would never be an excuse to, like, bribe a foreign official, which is, banned under the Foreign Corrupt Practices Act. Let's say you bribe a foreign official, be like, oh, but I thought that bribing a foreign official was legal. I wasn't sure that this was, I didn't know that this would be considered a thing of value that would subject me to the Foreign Corrupt Practices Act, or I thought wrongly that I fit under a category and I made the right. Do you understand what I'm saying? So, like,
I do. So again, as the layman just interpreting for the stream, We know objectively that 34 times, at least 34 times, Trump Trump falsified business records.
This is barely even contested, right? I mean, Rob admitted it when I got him on that, and I did get him, and he had to admit it when he said, yes, Michael Cohen stole $60,000. What he's telling us is all that this was a reimbursement, which we already knew, but Rob Noor is conceding this is a reimbursement. And in conceding it's a reimbursement, he knows that this was paid as income to Michael Cohen. And why would he do that? Why would he impose taxes on himself for a reimbursement that you don't need to pay taxes on? Come on. We know that this is false. And so they don't really even concede the falseness of the records. The only question then is the underlying purpose of it. And I think
so even that, again, just to be clear, so he falsified at least 34 records. We know that. We've seen the checks, we've seen the records.
And they practically conceded. Trump doesn't, though.
Right. The testimony that was provided by the likes of Hope Hicks and David Pecker and others proves the second part, which is that this was done in an attempt to influence the 2016 election by unlawful means. The unlawful means is one of three things, and one of them, I really want to focus on the Federal Election Campaign Act, because that was the one we spent the most time on. He factually violated FICA because the checks exceeded the sum permitted by
not
FICA.
In 2017. No.
Oh.
So at the time, because those weren't campaign expenditures or contributions, the payments to Cohen. It's a little bit weird, but they were after the election, right? So how can they be campaign contributions themselves? No, the illegal campaign contribution was there's two, or at least two. I think there might be three actually, but there's two that I know about. The third one is missing right now. But the
no, you're right. But Cohen paid her.
Cohen paid her.
Yes, yeah.
Donald Trump.
Yeah,
and federal election guidelines say that the value of a loan for purposes of federal election law. First of all, we all know that loan was valued more than even if the rule weren't this, we know that loan was more valuable to Donald Trump than $2,700, right? So that's just number one. And number two, there's additionally federal regulation that says if the loan exceeds the individual contribution limit, the value of that loan is considered whatever the nominal value is. And so for purposes of the election law, he gave a $130,000 contribution to Donald Trump. And even though it was technically an expenditure, you could argue that it's an expenditure by Michael Cohen. If that's your theory, well, then Trump directed it. And so a directed expenditure is considered a contribution.
Gotcha.
And it's also a loan. And so a loan is like a direct contribution to Donald Trump.
So it wasn't Trump paying him back. It was either the directed contribution or the directed loan.
Right. And they're kind of two sides of the same coin. They're kind of the same thing, right? And then that's one, right? And the second one that I know about, I think there's a third, but the second one is Trump but Trump was the reason behind the payment from AMI, which is the parent organization of National Enquirer. It's essentially David Pecker.
Right.
He got David Pecker to pay $150,000 to Karen McDougal.
Right.
And any corporate contribution for the same reasons, right? If you consider this a loan, though he never paid it back, right? He never paid Pecker back, which is why Pecker never paid for the Stormy Daniels one. And the reason it's not an extortion, by the way, guys, who did Stormy Daniels reach out to? Did Stormy Daniels reach out to Michael Cohen? No. Stormy Daniels reached out to Pecker. And the reason she reached out to Pecker was because she thought Pecker was going to publish it. She reached out to Pecker and or his whatever the editor, I think his name is Dylan Howard. Yeah, Dylan Howard is the name of the editor in chief. She reached out to them to buy the story, and only then did Pecker refer them to Cohen to get the NDA. Right. So it's not an extortion. It was, she was going around trying to sell the story. Right. Anyway, neither here nor there. Trump, in saying, yeah, I'll pay you back, Pecker and AMI and National Enquirer, he facilitated a payment from a corporation to a person for the purpose of the campaign, which is also against FICA, because you can't corporations are not allowed to make contributions to candidates. They're allowed to make independent expenditures, right?
Sure.
That's Citizens United in other cases, right? But they're not allowed to directly contribute. And so that's that one, and that's the phone call with Cohen that you guys hear, is him saying, "Hey, I've talked to our friend David." Who? David Pecker. He's like, and Trump's like, "How much do I have to pay? 150?" He says that, right? So he's aware of this payment.
Right.
He's aware who's paying it. He's aware what it's for. They had a meeting in Trump's
He's
tower.
materially involved,
Yes,
according
yes,
to
they-
the
it's
audio
obvious.
files.
And I know you say it's the weakest in terms. The only reason I say that it's the weakest, I would say, or the weakest, would only be because I think the other ones are much more serious. But I actually don't even like the word weak. I think it's overwhelming evidence.
That's fair.
Of guilt.
That's fair. When I say that this, I think this is the case that would swing the outcome of the election the least. You're right. And I'm not in a position to dictate this because, again, I'm not an attorney, which is why I think did the prudent thing, which was defer most of the question, or most of the vast majority of the argument to you, being that you are a practicing attorney. When I say that, it's just the seriousness of the crime. And regardless of the technical merits of this case, I do think it's fair to say, and perhaps just because of dirty pool played by Republicans and MAGA, is that this is the case which is the least straightforward to American laymen. This is the one that's hardest to explain compared to the others. I'm not saying that at all undermines the technical legal merits or the validity of the conviction, but that's why I say I think it'll have the least outcome in the election. Of course, the irony being it's the only one that we're going to see prior to the election itself. So I do want to direct in a couple of things here. I do want to talk about the conversation that we had on Just So Extreme and see if we disagree on this at all, because I was stunned. I was like, I remember thinking afterwards, I either miscommunicated or they misunderstood, or perhaps both. But do you understand, especially given our previous conversations about the judiciary and the importance that I put on the obligation judges have? As I'm not saying that there is a legal basis for recusal. I'm just saying, starting from this, my worldview is, given the enormous discretion and authority of a judge, I do believe that judges are morally and obligated to comport themselves in a way that I think it's perfect. If I have to choose between a partisan judge or a partisan prosecutor, a partisan judge to me is infinitely worse, because they occupy a role, in my opinion, where they are to be indulged the least amount of bias. A prosecutor, by definition, is adversarial, so I expect there to be a level of bias here. To me, a judge, you've got to be as close to a fucking android as possible. And if you don't, there has to be oversight and due process to evaluate your decisions. So on Just So Extreme, you and I briefly talked on a side tangent between you and Rob about Judge Merchan, the judge presiding over this case with Trump, and Justice Alito. And my position was, I do actually sympathize with Republicans who felt that Merchan needed to recuse based on this $35 donation. But I said the reason that I felt much better about that compared to Alito's choice not to recuse himself is that there is level of due process and layers above Merchan that would and did forensically examine any potential conflicts of interest pertaining to this case. They forensically examined the situation, the contribution, the law in question, and they basically said, no reasonable person based on our investigation could question his impartiality, though they did caution him. Yeah, that doesn't alleviate everything for me. I still have mixed feelings about it, but at least I can say, great, there was some level of oversight, due process, and evaluation, and it wasn't 100% left up to this motherfucker to make his decisions. Whereas with Alito, there is no due process. It is entirely his discretion. Chief Justice Roberts can't kick him off the case. I feel much worse about that. I think that is wildly inappropriate, a huge weakness in our constitutional system, this idea that everybody else gets oversight, everybody, except these 9 unelected fucks. That doesn't work for me. It doesn't matter if it's a conservative justice or a liberal justice. There should be controls and oversight for that. And the fact that there isn't for Alito, I think I am perfectly justified in feeling much worse about Alito's decision not to recuse himself from these Trump-related cases than I am with Merchan choosing not to recuse himself from this case, given, again, the oversight and due process. That was my position. What do you disagree with?
Yeah, I guess thank you for clarifying, number one. Yeah. I think that what was going, as you distilled it just then, what you're saying is, I agree that the concerns are valid. I think that that's fine. I don't disagree that you think and honestly do, and I don't disagree that it is fine to have concerns. And I think all of us would be concerned, and I think you're acknowledging that, if there were like some payment to Trump, right? Some contribution to Trump, we'd be like, okay, like what's going on here? Is this okay? And so I understand what's going on. Like,
I have concerns about Cannon, and Cannon hasn't, as far as we know,
Yeah.
contributed anything to Trump. She was merely appointed by him. But I think I am uneasy about that as well.
Yeah, no, so I understand that. I take your point. I don't dispute that. I think what happened in that discussion was there was like a hypothetical about, would you be calling for Merchan's recusal, same facts but Trump? And I think I heard your answer to be, yes, I would be. And maybe you meant, or maybe you were just saying if he hadn't gone to the panel or something. But am I hearing you now that you're saying that I would treat, if they had given the same facts but for Trump, I mean like MAGA guy,
Right.
would you be calling for his recusal? I think the answer is, had he gone to the appellate division or to whatever committee appointed by the appellate division, you would not be calling for.
No, I would accept the outcome. I would still probably be uneasy about it because, again, I have an unapologetically superhumanly high level because of just the way that I conceptualize democracy here. That it's not that I don't expect quite a bit of our elected representatives, but I understand that there are controls for them both internally, so but also externally as well from the other branches. And the way I look at it now, and you weren't here for this conversation, but this is why I said I want to follow up with Lactoid. Lactoid admitted when he and Econoboy, and I can't remember who the other one was. It might have been Wick. It was Wick and Lactoid versus Econoboy and I on a Wick panel a couple of weeks ago about Alito and the flag situation. Even Lactoid admitted that for all intents and purposes, he believes the Supreme Court to be the most powerful branch. And as somebody who studied political science and who believes in a democratic republic, it is unacceptable to me. It is violently, I don't mean violent, but it's like viscerally unacceptable to me that the most powerful branch is the one with the least amount of oversight and checks against it. Especially when you consider, I mean, conservatives cite the founding fathers all the time. They make it abundantly clear that as powerful as the judiciary was, it's a separate branch. It was not intended to be the most powerful. It was supposed to be the weakest of the branches, and the president and Congress be much more powerful and active. The judiciary was meant to be a brief and inactive brake check. And yet it seems like in so many ways, checks and balances goes in one direction. The court can impose its will on Congress. It can impose its will on the president, but there's no viable practical means for the reverse. As a matter of fact, with the president, the only real option is non-acquiescence, is just saying, no, you and what fucking army? And Lactoid and others would say that that's non-constitutional. Of course, the president can't defy the Supreme Court, but it just doesn't work for me. We have to impose oversight and checks on this court. And so anyway, that was
I just take a very different view, and I do want to mention the Alito thing. Although I'm seeing right now on Twitter, there's the neighbors coming to call out, and so if Alito made a false representation, I might feel differently about what I'm about to say. I do think that they're distinguishable, kind of in the way you're suggesting, but there's other aspects to what's going on here that trouble me about the people who call in for Alito's recusal, which is essentially like, number one, I buy, subject to me hearing what this neighbor says, I fundamentally buy that like. The chronology probably had the Mrs. Alito kind of taking charge of that situation. That strikes me as believable, given that no one seems to dispute that there was an argument that was mostly centered around Mrs. Alito. Like, that all sounds correct to me. And I don't like, unless there's some really like evidence of some extremely bad conduct, I don't like ascribing the actions of someone's partner to them. I think they're different people. I think that's, they're allowed to be politicians. They're allowed to be political. And even though it might reasonably cause some people to doubt them, I think that this is like an exception that we have to make if we claim to live in like kind of a free and equal society where a marriage isn't just the doctrine of, what's it called, covenanture, whatever the doctrine was, where you would like become part of the man.
The
right?
two shall become one is rooted in
I
biblical
don't like
theology.
that.
For legal purposes, they have to be separate entities. I understand that. Yeah.
So like, that's one of the reasons why I think the Alito thing So I'm not calling for his recusal for that reason. I think
May
that
I ask you this?
he has a duty
Can
to
I
hear there.
can I ask you just one question, one hypothetical? If it had been Alito
hmm
who flew the flag, would you feel differently?
That's tougher. That's tougher because it would actually then at that point depend on the flag, right? If everyone agrees with this, I hope everyone agrees with this, and I think you will. There's two steps. Number one is Alito even involved? Is his conduct at issue? That's number one. And number two is, what was the display? So let me give you an example. Let's say that his wife put up a swastika, right?
Sure.
And I'm okay with Alito not immediately taking, like, right, so like, I'm okay with Alito taking reasonable efforts to de-escalate and get the flag down, as long as those efforts are reasonable. And it seems that that's what he describes, at least, and it was taken down. Like, I'm not imposing on someone a standard of like, take it down right this second, otherwise whatever, right? Like, it's not like tag you're it. But assume that there was a swastika flown. If Alito had taken reasonable efforts to take it down, and it was his wife who put it up, I still wouldn't say that Alito has to recuse himself, even though the flag is the most objectionable flag it could be, right?
Sure.
Because it wasn't his action, and he tried to stop it. Assuming those facts and assuming the neighbors telling the truth, all that stuff, right? Or not telling the truth. Now imagine that, it was Alito's conduct, but it was a Patriots flag. When I say Patriots, I mean the football team, Patriots.
Right.
Well, then it's okay. It is his flag, but it's just not an objectionable flag.
Sure.
So there's two parts to it. Like, was he involved, and what's the flag like? And if you could show, and I think the evidence here is somewhat significant, that this is a flag related to MAGA, and if it was Alito who flew it, I think that I'm not going to say it because I don't have a lot of.
Sure.
I'm not an ethics attorney, but that raises a serious question about the appearance of impropriety.
Right. And I guess that's the other part for me too, where, again, kind of like with you in this conversation, and this is part of the reason why I like chatting with you about politics and the laws, because whereas I feel very competent in my political knowledge and political history, I think with matters of law, I defer to you. And this is something that I told Lactoid during the conversation about Alito. I said, listen, you have me at a disadvantage because I'm not an attorney and I didn't go to law school. And I said, but one of the things I can do very well is read and defer to other attorneys, and who, with all due, and I told him, with all due respect, who have more experience than you, are better educated than you. And there are, I'm not saying it's a consensus, but there are plenty of practicing. There was, I know at least one federal judge, former federal judges, judicial ethicists, law professors who said, this is sketch. I'm not saying that means you have to side with them, but do you at least agree that there is a debate to be had about this situation? Or would you say no?
I think there's a factual debate, but if you take Alito at his word, I think he made the right decision. That's what I'm saying.
Gotcha.
And I hate MAGA, the movement.
I know you do.
There's
there's no question about that.
And I want to be clear, I don't hate all MAGA people. And I think that there are a lot of good people who are Trump supporters. I'm not saying that they're not. I just don't like what the movement stands for. That's what I just want to clarify. That's what I mean. I don't like the values of MAGA. Yeah. I think that the insurrection was one of the worst things in our country in terms of January 6th. So I'm not one of these people to downplay it, but I just don't think that there's enough tie to Alito there. The one thing you should be worried though is like the other ratchet, right? Because you do have to be consistent. If this were just a Make America Great Again flag, let's say that Alito flew it, right? And he on purpose flew it. Would we have we should have the same reaction to that versus Yes We Can Obama flag, right?
Sure. 100%.
I think it's a little bit harder when it's like something, say for instance, the Don't Tread on Me flag versus the Black Lives Matter flag, right? If Sonia Sotomayor put up a Black Lives Matter flag, what would you say, right? I don't know. If Alito put up a Don't Tread on Me flag, what would you think? I don't know.
Well, because those flags are less directly. I mean, those are a bit more politics, abstract,
right?
And broader social movements, and not the personal following of one of the petitioner in a case that they're seeing. I mean, it was Wick who brought up Justice Ginsburg, and I'd completely forgotten about this, that she talked mad shit about Trump in 2015, 2016, prior to him not only being elected, but prior to him becoming the Republican nominee.
Yeah.
And so I went back and reviewed and brushed this up. And there also were judicial ethicists at the time saying this is wildly inappropriate. And she did walk, and she eventually came to that conclusion too, because within a matter of weeks, she was like, yeah, I fucked up. I should not have said this.
Yeah.
And I just want to be clear. This is how consistent I am. She should not have. This is what I mean. Like, I am viscerally opposed. If to me, I'm just sorry. I cannot wrap my head, and I don't think many constitutional scholars at this point can either, where we ceded too much to the structure of the court based on good faith. And their approval rating and the perception of good faith is in the toilet. And I'm thinking to myself, again, I just go back to, you get all this fucking power without any account. You don't have to worry about elections, term limits, mandatory retirements. You don't have to worry about a binding code of ethics. There's no way to file a real official complaint with the Supreme Court. You get all this power. Your one fucking job is you don't get to behave like a politician. I, as Senator Josiah, can say whatever the fuck I want, whenever I want, as partisan can be. As far as I'm concerned, you don't have the right to do that.
No, I get it. I guess, and I do want to take on your kind of structural analysis of the Supreme Court, because I couldn't disagree more with Lactoid about the power of the office. I still think the president is the most powerful branch of government right now, the executive branch. Not saying that that's always the case or that's what it was intended to be.
Could
the
you
case.
break into that? Because I am interested in that.
Yeah. I just want to do my last thing on Alito is, again, I'm someone who constantly criticizes Justice Alito, Justice Thomas. I think Alito is not doing a good job as a justice. I think that a lot of his rulings are just really bad. And so I'm not someone who likes Alito. I'm someone who does not like these flags, these insurrectionist talk. I couldn't be more against Trump than there is. I just think you need to be realistic here. These are people. I assume that Mrs. Alito is MAGA anyway. I kind of assume these people have those opinions anyway. And like, as for Ginsburg's comments, like, yeah, I assume that would be her opinion anyway. And as long as they like walk it back and they do what they can to like, all right, stop flying the flag or stop making those comments, I'm going to give a lot of leeway to judges who do that, because listen, our assumption has to rest on them being able to put aside their biases. And unless it's like a flagrant and continuing violation, because we do that for juries too. We say that ordinary people are able to do that. And so if there's a continuing flagrant violation that's not corrected, or like a one-to-one payment situation kind of deal, or a principal agent thing, that's one thing. Or a commission of a crime where there's like, potentially liability at stake for a judge. Those are kind of more situations where I think, okay, this is too much. But for the general political belief, it's going to have to reach a certain threshold.
So I just want to say a couple of things on that. So the jury thing, as a point of comparison. Well, first you said something about Justice Ginsburg, about her walking.
Yeah, her comments like walking it back. You take down the flag. That's all fine, provided you're not lying to us. And Alito could be lying to us. And I see someone putting something about the timeline not matching up. I understand there's a timeline issue with respect to like when the fight happened, but there was signage before it, and so there's the chronology doesn't start in February with the neighbors. Sure. It does start in January. So I think if you accept Alito's taking the fact,
I do think that there's a dispute about the chronology, but I'm not even getting into that at that point. You said that's the Ginsburg thing. Damn, you said something that I wanted to respond to. The jury thing. I'll go to the jury thing real quick. The reason that the jury comparison with respect doesn't work for me, at least immediately, my visceral reaction is, there again controls on the jury. The judge is a check on the jury in with certain respects, issuing jury instructions, what the jury can consider, what's stricken from the record. There's the jury selection process itself, where the integrity.
It's adversarial.
And all these things are questioned. So to me, it comes down to, like you said, you said it. There's trust. But as far as I'm concerned, and I know you would agree with this, the Supreme Court has a moral and civic obligation to prove its trust to the American people. I don't think the idea is I become a Supreme Court justice, I can do whatever I want, and you must trust me. I would say, no, you must, with every utterance, prove and reaffirm the trust that we have in you. To me, just the insane level of discretion, I believe, based on like even Alito's response, the impression that I get is this idea, I've been confirmed, it's a lifetime appointment, and kind of like almost like I'm not married, and I don't think you are either, but almost like I have the ring, you married me, and now I don't have to earn your trust. I can actually do things which would cause you to question my trust, but it doesn't matter. You trusted me enough to marry me 10 years ago. And I think any successfully married person would say you have to reaffirm the trust in that person every goddamn second of every day. It has to matter to you. And I don't believe that Alito, and I don't think it's just the conservative justices, by the way. I don't think the liberal justices should be entitled to this level of discretion. I question the extent to which these justices feel compelled to prove themselves to the American people. I don't think they take that obligation seriously. It disgusts me. And that's why, again, I really hope for one day, and I do think it will happen, this court is going to get reined in. It could be 5 years from now, it could be 20 years from now. But I think eventually the Supreme Court of the United States will look much more like what we see in Canada and other places, where the slack they're given is tightened considerably. And I think that'll be a good thing.
Yeah, I mean, I take that. I understand that. I advocate for Joe Biden expanding the size of the court. There could be, so long as the reforms are constitutional. And I've seen some proposals that I don't know about. Of course, understanding the Supreme Court itself has somewhat of the last word, or we think they have the last word on whether or not the reforms would be constitutional.
Because
right?
I imagine that if Biden wins the election, we keep the Senate, we take back the House, and let's say there's an appetite to pass ethics, like an enforceable code of ethics on the court, which, by the way, I do believe that is perfectly within the province of the Supreme Court, or excuse me, of Congress to impose. Congress
what's the punishment?
Say what?
What's the punishment?
That's where
they can't do that because that's there's constitutional prohibitions on like lowering pay, right?
Right. So that's it would have to be some sort of mandatory recusal process after it. So the way I'm thinking about it, there has to be an enforceable code of conduct, which means with respect to judicial ethics, there has to be an oversight body. It could be the chief justices of the various circuit courts or retired judges, a rotating panel or whatever. There has to be a way to file a complaint, a due process and review. And then, the only constitutional way to get rid of a federal judge or justice is to impeach them. That's not going to happen, but it could be a mandatory recusal or something like that.
Yeah.
But I think that's a fair question. But you're right. If that's a matter of federal statute, which it would be, short of a constitutional amendment, then I wouldn't put it past this fucking court to say, actually, that's justiciable. We can review that. And then, of course, they strike it down.
I mean, you could do something clever like saying, this is the statute, and no court of the United States shall have the jurisdiction to hear appeals to the constitutionality.
Article 3 gives them the Congress the power to select.
That's like a holy hand grenade. That's people talk about the nuclear option with respect to the filibuster, which I think is nonsense. But I think there is a nuclear option, which is pass laws and make the Supreme Court strip jurisdiction for the Supreme Court to hear their constitutionality. That's just like oof. No, I don't like that thought process.
I mean, listen, I'm not saying do any of this recklessly, but I do think something's got to give, man. Like, this is just ass.
I think all of I totally disagree with so many Supreme Court rulings, especially this recent Anderson case, and including the liberal justice who ruled incorrectly that he wasn't ineligible under Colorado law, and just like totally whiffing on, in my opinion, basic structural facts about the Constitution, including the fact that the states are the ones who assign electors, and they have close to plenary authority to do so. And you just see Ohio like flirting with the idea of not having Trump on the ballot Biden on the ballot for some like procedural mix-up.
Right. Like, they have never, that in previous situations, this has been the standard process, that they have never concerned themselves with the nomination date of either candidate. But now it's a fucking problem.
But the thing is, like, I think Ohio should be allowed to make procedural rules for who's on their ballot. They're electoral votes. And the people of Ohio will, like, that to me, I don't agree with the structure of it. I think it should be a direct popular vote, and we should get rid of this whole state thing. I don't ever agree that we should have this like bizarre electoral college in the first place. But if we're going to follow the rules in the Constitution, like, I think it's clear states decide electoral votes. So that was all for me to show you that I really, really disagree with the Supreme Court and a lot of, or at least the recent rulings, and a lot of even the liberal justices' rulings on some of this. I think they're bizarre and wrong. But if your main focus is Supreme Court, I'm like, I don't know where your priorities are. I think the main concern is the people. The people are crazy right now, and and Congress is crazy, and the presidents are crazy. I'm more scared. I would be more scared of a Trump 4-year presidency than this is how honest I am with you. I would trade 2 Supreme Court justices for Trump not becoming president for 4 more years. That's
I
how
probably
different.
I probably no I probably
view
agree.
that.
I'd probably take that bargain too, because
Yeah.
it doesn't matter. It's already favorable to Trump
Yeah.
anyway, be it a 6-3 conservative supermajority or an 8-1, right? To your point.
Yeah.
And listen, this is what I mean, where it depends on how you define power. I don't dispute that in terms of day-to-day activity and the versatility of authority, like the wide portfolio. There's no question that the president is the most powerful of the branches. Number one, because he's basically a branch unto himself, whereas we talked about with Congress, it's
Operate with
bicameral,
consensus,
right? Yeah. And unlike the Supreme Court, where you can judge shop and make its way up until they grant cert,
but there are limits there, and
they still can't proactively do. I don't doubt that. But I think, and this is what Lactoid's point was, and I was really happy we came to a consensus there, because I thought I was crazy for the longest time. He's like, basically with the norms that dictate the relationship between the branches, he says that when it comes to the things that matters most, the Supreme Court is most powerful. And I agree with that, because in theory, it's still the weakest. In theory, President Biden could say the next time that they make a ruling, no, right? And again, the Supreme Court would be shit out of luck.
Yeah, but I'm not talking in theory. I'm talking in practice, Josiah. I agree with you. In theory, Congress is the strongest branch.
Right.
But I'm operating, when I am assessing power, I'm not saying from a kind of first principles, founding of the Constitution, design question. I'm saying like what is in the real world. And the truth is, the parties, Congress, it's not really a check on the president in any real meaningful branch sense. The check is partisan. And really, like, the president kind of runs a bit of the show, and even in terms of what happened in Congress, right? Like, if Biden says jump, maybe not all Democrats, but a lot of Democrats are going to say how high.
He's effectively the chief lawmaker, especially after decades or centuries where most bills, especially like the budget, people say that Congress controls the power of the purse. Well, it's the president who proposes the budget, and their budgets are overwhelmingly, like the vast majority of their budget stipulations are met. I don't dispute that at all. But I guess the way I look at it, if you and I have a relationship, and I do, let's say the nature of my job is such that I do the day-to-day work and you are merely supervisory. But if you can tell me what to do and I can't tell you what to do, how are you not more powerful than I am?
Because it doesn't work that way. I mean, the Supreme Court rarely ever sort of directs any order to the presidents at all, if ever, right? Usually, yes, in the course of like judicial review, they might strike down a law, but remember that law is a product of bicameralism and presentment, and so it's not the case that like the Supreme Court is constantly checking every single one of these actions. I agree that there are some executive actions that the Supreme Court sees a lot of, and the president will pay deference. But like, look, that oftentimes doesn't stop the president from doing something like what they wanted. Like, look at Biden with the student loans. Yes,
sure.
His initial theory, which was broader, was denied, but he has taken other efforts to just do kind of similar things. Right. Same thing with some of the immigration stuff, where yes, okay, we had to suspend the rescission of DACA, but Trump.
Yeah, and some of these, just FYI on that front, on the immigration front, you know this better than most. Some of those orders against the government came not even from the Supreme Court, but just a federal judge. Like, federal judges can stop executive action and effectively give orders to the president. No, you cannot do this, or you must do this.
I'm much more scared in this day and age, and I'm just being honest with you. And that's why I think this election is so critical. It's not, and it is also critical because the Supreme Court has a lot of power. I'm not saying they don't have any power; they have a ton of power. It's also critical because we want to put like justice on the Supreme Court, and you can bet your ass that Alito and Thomas
they're going to retire the 3 days into a Trump
guaranteed. So one of the reasons for voting for Biden is obviously for the Supreme Court, but I'm just saying, sort of in the grand scheme of things, I'm much more scared, to be honest with you,
Sure.
about a rogue president than a rogue Supreme Court.
All I'll say is I completely agree that the immediate threat is from a Trump presidency, again, because of the agility and the activity of the executive branch and its role in our day-to-day lives through federal bureaucracy, through its command of the military, all these things. There's no doubt about that. I think that the long-term problem, though, and by long-term, I'm not even saying necessarily centuries from now, but decades to come, will be this court, and that's why I think that these things, it's not either or, it's both. We have to address both. But I'm trying to get an interview with Jamie Raskin. I'm working my ass off for that.
That's
and
awesome.
This is also something that I want to talk to him about, because right now he and Sheldon Whitehouse are leading the effort. By the way, actually, last question for you on this.
Yeah.
Do you like Dick Durbin? I don't. Do you like Dick Durbin? The chairman.
I don't know much about him. Are people mad because he's not like
holding hearings or investigations, stuff like this?
Yeah, I think that's a politically calculated maneuver to not distract the country from like Trump's failings and all that stuff. And so I think that when you guys see like the lack of action there, I think that there's a deliberateness there that might be. I think people are assuming it's incompetence. And I definitely agree that there's a lot of Democrat incompetence, especially in
or fecklessness, or just fecklessness. Yeah,
I mean, that exists as well. But if this is a purely political calculation, if that's what we're thinking it is, then because we know it's not going to result in any like permanent thing, or any kind of like substantive change, then I think that might be what's going into it, and I might agree with it. If you think as a matter of like just principles, you need to be able to air out what's going on here, regardless of what the political ramifications are. I guess, but to me, it's not, unless we get more information that I'm not privy to, it's not a priority for me. The priority is highlighting this criminal former president who's trying to gain power again, how we try to see an election. That should be the focus of the American people. And it's kind of like all hands on deck. And so to the extent that we can like stop, like if you drag Alito there, Democrats are going to look bad, and so, and I don't understand that.
I don't know. I take your point that there could be a political calculus involved besides just outright fecklessness, but it certainly presents itself to me as fecklessness. I feel like the situation is different. If again you had Jamie Raskin chairing the House Judiciary Committee and Sheldon Whitehouse chairing the Senate, but fair enough. Last question, actually, when do you think we're going to get the
one thing?
Yeah,
and then I'll respond. So just to be 1,000% clear, I haven't really thought that much about the principled aspect, because I do believe like some things matter more than politics. And so like if I knew, for example, that the January 6th hearings were going to hurt Biden, I'd still want them, because I think that it's just a matter of principle that the American people deserve answers.
That's how I feel about the Trump trials, and I'm sure you do too.
Yes.
It's like this may backfire. Like when I hear Piers Morgan say the left is fucking up by prosecuting Trump, and I'm like, well, number one, I reject your premise, but number two, even if the prosecution of Trump electorally advantages him, I'm sorry, I do. This is one of those times where I'm not, a purely political machine. I have to know that rule of law matters. So yeah, I know, I completely agree.
And so just to distinguish the hauling Supreme Courts into Congress, one, it's a little bit unprecedented, I think, to like subpoena them to present themselves in front of like an open hearing. Yes, justices have come and spoken at Congress before. I've never heard of them being forced to or subpoenaed or anything, and I think that is like, that would be like a whoa. That's like a branch conflict right there. And I think the hearings, because I don't think that some Democrats prepare well for these hearings, some don't, and their questions suck and they look horrible and they embarrass themselves.
Maybe they need to hire Pisco for some work.
Maybe. And then also, I don't know. Like we can make the case that this is bad if it is bad, or like ethics problems without doing that, right? There's a ways to get the same point without doing like the most outrageous thing possible. And so I don't know what testimony you're looking for Alito, or like how you're going to get him to, so that's just I don't see it as productive. I don't think it's necessary. If other facts come out, they're like, whoa, he flew it. Whoa, he has financial ties to this. Like, okay. But I'm not, it's not a priority for me.
Yeah, I just think overall, and I'm not even referring to the flag situation at this point, because as far as I'm concerned, it's not even like in this particular situation, like I'm also wrapping in Clarence Thomas's disclosure situations. The fact that even now they still violate
that one troubles me more than the flag, to be honest.
Sure, no, 100%, same here. When do you think? Last question. When do you think we're going to get the ruling on the immunity case, and what do you think it will be at this point?
I think end of the month. I think it'll say there is such a thing as presidential immunity, absolute presidential immunity. I think it'll say absolute presidential immunity exists within some nucleus of presidential official activities. I think this will be a fractured opinion with the controlling opinion, probably Amy Coney Barrett or the chief, probably the chief. He likes to write on these things. I've not been a fan of the chief's writing or doctrine lately. I think it's bananas. So I'm sure I would hate the opinion if the chief wrote it. And so yeah, I think that will require an evidentiary hearing. I think they'll probably maybe give you some examples and be like, okay, for example, ordering the DOJ is probably per se, I don't know, absolutely immune for that stuff. It seems crazy to me, but like, I think that's where we're at. And I don't deny that there could be a sphere of act which is so integral to the presidency or central to the presidency that you can't criminalize it. Like imagine like you try to criminalize pardoning people, right? Or you try to criminalize like walking around for the president or something like that, right? Like,
well, but that's the thing, right? So it's funny you say the pardon thing, and I'm thinking to myself, almost like the ambassador's colloquy that was given, this idea that, okay, what if, yes, the president has plenary authority to nominate ambassadors. Of course, they have to be confirmed with advice and consent of the Senate.
What if you bribe them?
What if you bribe them? And that's just like, man, I want to have a conversation. I genuinely want to have more conversations about this, especially as we get closer, because to me it's fascinating.
Yeah.
But yeah, I'm so weirded out on this idea of.
But there you wouldn't be charging the appointment. It would just be, could you use the appointment as evidence?
But isn't that the one-legged stool thing, that if he has absolute immunity for the appointment of the ambassador, then you can't review it. And so then you can't prove that second component of the bribe, and it's the one-legged stool thing.
Yeah, but there I would say, I would distinguish between, yes, I think that was a good point by the chief in oral argument. I remember it quite well. It was a good question, and I think it indicates that we're not going to have a complete, at least I hope, I'm not predicting a complete 6-3, like we accept all but Trump's most crazy arguments. I'm expecting a more like, Trump can be liable, but you need an evidentiary hearing, and that's going to take you 3 months or whatever to like litigate out.
And then they'll review it again, maybe.
Yeah, so, and then they'll be like, "Oh, we disagree with you. Clear error." Sort of on the question of how would I conceptualize it? I'd be like, well, it wasn't a crime for you to make the appointment. The appointment is valid. You still have the power to do so. But the intent behind the exchange of money, like, and I understand there, yeah, because you're saying like, what good is the absolute immunity if you can just peck at everything around it? I guess is the point, right? I don't know. It's a complicated issue. I never said it was a simple issue. The simple issue is like, he can't just ignore all federal law, right?
Agreed.
And the more complicated questions are like, well, when we start getting closer and closer to like the center of the president's authority. And I don't think the impeachment argument is a good one, that you need impeachment. That doesn't seem to be evident in either the text of the Constitution, historical practice, or anything like that, given like the Nixon pardon when he wasn't ever impeached, that kind of thing. So like, yeah, I have a lot of problems with the maximalist versions of all this, but I think the DC Circuit probably got it right. But I don't expect them to uphold the DC Circuit opinion, if that's your question.
God, that makes me so sad. Okay.
Yeah, I think that's not going to be good law.
Well, I appreciate you weighing in, buddy. We're going to have to do this some other time.
Yeah.
And you have a good one, all right?
Thanks. Much love to your audience, and I really appreciate you having the time to have me on.
Yeah, 100%, dude. Always. And again, once my schedule calms itself down, the regular project with you and Econo Boy, we got some ideas on that too. So
yeah, no, that sounds great to me. And yeah, let's talk about that. You're blowing up though, and keep it up, because I think you're doing a great job.
I appreciate it, brother. You have a good one.
All right.
All
Later,
right. See ya. And audience, thank you. Hope you guys have a really good night. Bye.